Where I can start the video. I mean, there's still some picking up on the overall, but right now I can get this one more. And I'm waiting to go.
Commonwealth versus Michael Austin. Sentencing. Are you Michael Austin?
Yes.
Good morning.
Come on.
Were you born in 1966?
Yes.
Last four digits, social security number 7734.
Yes.
We're here on 21 CR 0078. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yeah.
Okay, there's some corrections that need to be made.
Your Honor, I know one issue is that Mr. Garrett represented Mr. Austin during the underlying case. So, and I have represented him during this process. Still says Mr. Garrett. I think there might have been a little confusion. I don't think that matters.
No.
I don't know. You move over behind the microphone. You move over behind the microphone.
Okay.
You move to your right a little bit, sir. Let her behind the microphone. Explain to me what you just said.
The pre-sentence investigation report on the first page of it lists the attorney as Mr. Garrett that represented him. It is my understanding that Mr. Garrett represented him for when the case was pending, and then the public defender's office stepped in once we reached the revocation proceeding. So I believe that there was a little bit of confusion with regard to the attorney of status, but I do not think that
You
is.
just want to be replaced as attorney of record on the pre-sentence investigation report?
Yes, I believe that was
Okay,
what
we
it was.
accomplished that. Is there
Yes.
anything else?
No, Your Honor.
Okay, you had originally had 5 years pretrial diverted for 5 years. The diversion was for 5 years. The diversion was voided on 6/20/24 there. So therefore we'll implement the sentence of 5 years. Okay. Thank you very much. Dustin Cruz. Commonwealth versus Dustin Cruz, 24 CR 0055. Are you Dustin Cruz?
Yes.
Good morning.
Morning.
Were you born in 1986?
Yep.
Last four digits, social security number 6473.
Yes, sir.
We're here for a pretrial conference. Do y'all have anything to report in this case?
Your Honor, we are entering a plea on this case.
Is it a felony plea or a pretrial diversion?
It is a pretrial diversion, yes.
Okay. Mr. Cruz, I've just been informed that you wish to enter a plea of guilty today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is
Sir.
this plea freely and voluntarily given?
Yeah.
Okay, are you the person just identified as Dustin Cruz in 24 CR 00055? Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yeah.
Have you reviewed the evidence Commonwealth has against you and are you satisfied that you're fully informed about the case?
Yeah.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. Now I'm going to go over the rights and I'm going to ask you if you have any questions, okay? You have a right not to testify. No one can make you say anything. You have a right to speedy trial by jury. You have to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in your favor, a right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you, that you understand that by entering a plea of guilt, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to in the event that I do not accept the recommendation of the Commonwealth and decide to give you a harsher punishment. You have the right to withdraw your plea and go to trial. You understand that? Now, I'm going to ask you some qualifying questions here. Have you previously been diverted in the last 5 years? Do you have any felonies in the past 10 years? You're going to have to say something. It's a voice.
No.
It's a voice activated microphone. Okay.
No.
Okay. Are you currently on probation?
No.
Okay. Excuse me. It's a call I've been waiting for from the attorney. Hold on a second. Hello? No, I'm gonna have to call you back. I'm on the bench right now, okay? Text me, great. Okay, thank you, sorry. You understand if you fully complete the pretrial diversion, the charges will be dismissed, pretrial diverted, and you can have your record expunged. You understand that? Now you understand that if you do not successfully complete the diversion program and you're brought back in front of me, I can avoid your pretrial diversion and schedule a sentencing hearing. You understand that?
Yeah.
Mr. Stockton, will you come around? Will you move to your left, please, sir, and let Mr. Stockton get behind the microphone? What is the Commonwealth's recommendation?
Your Honor, Mr. Cruz will plead guilty wanton endangerment, first degree, receive a sentence of 5 years, pretrial diverted for 5 years. He'll have anger management and grief counseling scheduled through probation and parole. He'll have to enter and complete that. He'll receive credit for time served, have no contact with the victim except in relation to visitation with their children, and maintain gainful employment.
Tell me exactly what happened.
Evidently him and his wife or ex-wife were in a scuffle going down the road, and he was driving, she was a passenger, and he had her by the hair, and this is observed by an officer, and this is in accordance with the wishes of the victim. We've discussed this case, and that's
So you complied with the victim's rights, correct?
That's correct.
Okay. Okay, are you pleading guilty because you did commit the acts as charged in the indictment as amended?
Yeah.
Okay. Are you doing so of your own free will?
Yeah.
Okay. Knowing your constitutional rights to explain it's still your desire to go ahead and enter a plea and allow the court to fix your punishment.
Guilty.
Is it still your desire to go ahead with the plea, knowing your constitutional rights and allow me to fix the punishment?
Yeah.
Is that your signature on the document?
Yeah.
Yeah, I'll accept the pretrial diversion. And we'll sign it here, no, thank you. Sign it here in a minute. We'll need to meet with the probation parole officer over there. And when was he to be released?
You want to, today.
Okay,
Mhm.
we'll sign the documents to get to it, and he'll meet the probation parole officer, and meet you there and take some information, right? Amber Crow. Amber Crow. Are you Amber Crow?
Yes, sir.
You born in 1997?
Yes, sir.
Last 4 digits, social security number 1582.
Yes.
You're on 24 CI 0001 for a pretrial conference. What do we have?
Your Honor, we are entering a plea on this case. It is a guilty plea. It is not a pretrial
A
diversion.
felony plea.
Yeah.
Ms. Crowe, I understand that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person just identified in case number 24 CR 0001?
Yes.
Is your judgment impaired today in any way? Is your judgment impaired today in any way?
No, sir.
Okay. Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you and you feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. I want to make sure that you understand those rights. I'm going to go down through them at the end. If you don't understand them, you can ask me, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will still wait for pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose harsher punishment on you than you've agreed to, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
You'll step to your left, Mr. Stockton. What is the Commonwealth's recommendation?
Your Honor, Ms. Crowe will plead guilty to strangulation. She'll receive a first degree. She'll receive a sentence of 5 years, serve 8 months, balance probated for 5 years. She'll receive credit for time served. Her child will be determined by Monroe District Court where the case is pending, and she'll pay court costs at discretion of the court.
Is that your understanding? Is that your understanding, Commonwealth's recommendation?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Sorry, what?
Are you pleading guilty because you did commit the acts that you're charged with?
Yes, sir.
Okay. You do so of your own free will.
Yes, sir.
Knowing your constitutional rights, is explained to us, it's still your desire to have these right, give up these rights, enter a guilty plea and allow the court to fix your punishment.
Yes.
Okay, is that your signature on the motion and offer?
Yes.
I accept the agreement, order pre-sentence investigation report to be done by probation and parole. And you'll be back here on August the 15th for sentencing. Hershel Hammer.
Your Honor, B. Davis, we're actually waiting on some paperwork.
But Commonwealth shorthanded today because of sickness. We'll have to do the paperwork.
So if we could recall on it, thank you, Your
Come
Honor.
back to it. Dustin Jesse. Dustin Jesse. Mr. Hammer, they're having to do some paperwork for you. We'll bring you back out, okay? Sorry to inconvenience you. Dustin Jesse.
He's in custody, Your Honor. Are they getting it, Dustin? Husband Jesse. Okay.
Are you Dustin Jesse?
Yes, sir.
Were you born in 1991?
Yes, sir.
Last 4 digits of social security is 0707.
Yes, sir.
This is 24 CI 006. You're here for a pretrial conference. What do we have here?
Your Honor, in this case, the Commonwealth and the defense believed that we were going to have a resolution for today. Unfortunately, the information that we had with regard to his parole was not correct, but we believe that
The
we will,
information you have in regard to what?
to his parole on the old case.
Yeah, we thought we had it worked out. He was gonna be paroled. We had
His
a-
parole. Okay, I thought you were saying his role.
Didn't go through, but anyway, both of them did some checking with the Department of Corrections. If we could have one more month, we'll decide what to do.
It's always better to get parole than it is to get probated. Okay, you'll be back here on August the 15th. Sean Jones. Good morning, Mr. Jones. Commonwealth versus Sean Jones, 23 CR 0043 for a pretrial diversion revocation and 24 CR 0056 for pretrial conference. Mr. Jones, were you born in 1978?
Yes.
Last 4 digits, social security number 8640?
Yep.
What do you got, Mr. Stockton?
We have a felony plea, Your Honor. And that will.
Okay. A motion has been tendered. It says you wish to enter guilty plea to that today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is the plea freely and voluntarily given?
Yes.
Are you the same person just identified as being in indictments number 23 CR 0043 and 24 CR 0056?
Yeah.
Is your judgment impaired today? Is your
Yes.
judgment impaired today? It's not impaired. You know what's going on?
Yeah.
Okay. Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? Are you fully informed about your case?
Yep.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go down through the rights, and when I get there, if you understand them or have any questions, you can ask me then, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that? Okay, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendations, I will have a pre-sentence investigation report done by probation and parole. After reviewing that report, if I decide to impose a harsher punishment, you have the right to withdraw your plea and go to trial. Do you understand that? If you'll step to your left, Mr. Stockton, what's your recommendation?
Your Honor, Mr. Jones will plead guilty to theft of property lost or mislaid, delivered by mistake, over $1,000. The defendant shall receive a 2-year sentence, serve 90 days in jail with the balance probated for 5 years supervised. He'll pay restitution in the amount of $1,000 at the rate of $100 per month, beginning 60 days from the date of his release. Subject to the 5% clerk's fee. This will be jointly and severally with his co-defendant Truman Adams. The 2-year sentence shall run consecutively to Monroe Indictment 23 CR 43. The defendant shall receive credit for time served and shall continue his treatment with life skills. Have no contact with the victim.
Is that your understanding of the Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged in the amended indictment?
Yes.
Okay. You plead guilty of your own free will.
Yes.
Your constitutional rights still, if I explain to him, still your desire to proceed and allow the court to fix your punishment within the range permitted by law.
Yes.
You understand that after entering a plea of guilty, any future convictions will enhance the range of penalties.
Yeah.
Okay. Now, is that your signature on there?
Yeah.
Okay. I accept the agreement. Mr. Stockton did on the other case, the 23 case.
Yes.
You did revoke the pretrial diversion on that, or did
I
you?
was gonna leave that up, I told, I was gonna pre-trial the verdict again, but
Well, you can't pretrial divert him again.
that's right.
So we'll have to revoke that pretrial diversion and then allow him to enter a plea to this other thing, and you can run them at the same time.
That'd be fine, revoke it, we'll do it all.
Okay.
So essentially, the pretrial diversion on the original case could be voided, but you would be put on probation.
That'll get both of them out of the way. If we didn't do that, he might very well have that pretrial diversion still waiting on him somewhere. You know what I'm saying?
Okay.
So it'll be revoked, you'll have 5 years superseding on that, concurrently, please.
That's correct.
Okay.
Okay, we'll get the paperwork kind of adjust. You want to get the paperwork adjusted with him, we'll hand you the paperwork. Does that, anything else have to be done? I guess when you enter the judgment, you'll just do that, revoking his pretrial diversion.
I'll have to send him for final sentencing on that, but.
Yeah.
That'll be,
Well, he has, do we need a pre-sentence investigation report?
yeah, because he just entered a plea on the other one
Yeah,
anyways.
yeah, I didn't know if he'd been in custody. I guess we do.
Not say pre-
Okay, I understand. We'll do a pre-sentence investigation report to be done by probation and parole. Be back here on August the 15th.
Your Honor, if I may, I believe he has a little bit more time remaining on the 90-day alternative sentence. He did want me to ask the court.
Well, we'll take a look at it then.
Yes, Your Honor.
Take a look at it then. Timothy Jones.
Good morning, Your Honor. Zena
Hello.
Myers for Timothy Jones.
Are you Timothy Jones?
Yes, sir.
Good morning, Mr. Jones. You're here on 23 CR 0074. Mr. Jones, were you born in 1997?
Yes, sir.
Last 4 digits, social security number 4923.
Yes, sir.
We're here with your attorney on a pretrial conference. Have y'all reached a resolution in this case?
We have reached a resolution, Your
Is it
Honor.
a pretrial diversion or felony plea?
Yes, Your Honor.
Which one of them is it? Felony plea or pretrial diversion? Pretrial diversion. A motion has been tendered, says you wish to enter a guilty plea today. Is that correct?
Yes, Your
Are
Honor.
you currently under the influence of drugs or alcohol?
Yes,
Is
sir.
this plea freely and voluntarily given?
Yes, sir.
Are you the same person that was just identified in 23 CR 0074?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States you have certain rights under the Kentucky and United States Constitution. I need to know that you fully understand those rights. I'm gonna go down through them at the end. I'm gonna ask you if you have any questions. If you do, you can step away and talk to your attorney. You have a right not to testify against yourself. No one can make you say anything. Your right to a speedy trial by jury, the right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. The right to use evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty charged against you. You understand that by entering a guilty plea today, you give up all those charges. You understand that? You understand that?
Yes, Your Honor.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowable law. I don't have to accept the recommendation. After reviewing the pre-sentence investigation report, if I decide to impose a harsher sentence, you'll have the right to withdraw your plea. Okay? You understand that? Now I'm going to do some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, Your
Are
Honor.
you currently on probation or pretrial or diversion?
No,
Okay.
I'm on a court order to a rehab.
Where's that from?
Out of Tennessee. He had a misdemeanor in Tennessee on a DUI, Your Honor, and he was placed pursuant to that in Clay County Sober Living? Is that-
Yes, sir.
And he had been in Clay County Sober Living as of January. Actually, he began in November of last year.
Are y'all aware of that? Were you aware? Okay. So it still qualifies your
Yeah, my
position.
understanding is once he's released, he can go back.
Okay.
Actually, they're planning on picking him up once the court releases him on this case. If the court does accept the pretrial diversion, he'll be going back there. And
Okay,
he's
you
got to
understand that if you complete the pretrial diversion, this charge will be dismissed, pretrial diversion, and diverted, you can have your case expunged. You understand that?
Yes, sir.
If you do not successfully complete diversion, you'll be brought back before the court. And if I avoid your pretrial diversion, you schedule a sentencing hearing, you'll be a convicted felon, and that could be used against you in the future. You understand that?
Yes, sir.
Just step to the left there. Mr. Stockton, will you come over and give the Commonwealth's recommendation?
Your Honor, Mr. Jones will enter a plea of guilty to receiving stolen property over $1,000. He'll receive a sentence of 5 years, pretrial diverted for 5 years supervised. He'll pay restitution in the amount of $4,000 at a monthly rate of $150 a month, beginning 30 days from the entry of this plea. And that will increase to $200 a month starting January the 1st, 2025. It'll be in accordance with the restitution order entered herein to the to the victims. He'll receive credit for time served, have no contact with the victims, and agrees to obtain and maintain gainful employment.
Is that your understanding of the Commonwealth's recommendation? Move back behind the microphone. Is this gentleman a resident of Tennessee?
I'm sorry, Your Honor.
Is he a resident of Tennessee?
He is a resident of Tennessee.
Okay, I'd like a waiver of extradition signed here. Get him a form signed, okay? We got any of those forms?
Or Mr. Collins too, he'll have to put in the paperwork, you transfer. And see, he be allowed to down there.
You come here and get this and fill this out. And I'm gonna ask you in open court here is you'll waive any extradition back to Kentucky. We have any problems, you come back without a hearing, is that correct?
Yes, sir.
Okay, you go ahead and over there with your attorney and fill that out. You can hand it in after we finish here. You pleading guilty because you are indeed guilty?
Yes, sir.
Okay, and you're doing it so your own free will. Know your constitutional rights is still your desire to allow the court to fix the punishment within the amount range allowed by law. Is that correct? Is that your signature on the agreement?
Yes,
I
sir.
accept the agreement. I'll sign the diversion orders and as soon as you get that form filled back up and handed in, okay?
Thank you.
Thank you very much. Kyle Simmons. Commonwealth versus Kyle Simmons, 24 CR 0053. Are you Kyle Simmons? Good morning, Mr. Simmons. Were you born in 1990? Last 4 digits, social security number 8515? You're here today on a pretrial conference in 24 CIR 0053. What do y'all have to say on this?
It's a pretrial diversion plea, Your Honor.
Okay, a motion has been tendered according to your lawyer saying that you wish to enter plea today. Is that correct? Are you gonna have to say something? It's a voice activated microphone. Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person that was just identified in 23 CR 0074?
Yes.
Okay. Is your judgment impaired today in any way? Have
No, sir.
you discussed these charges with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over your rights, and at the end of them, if you have any question, you can step away from the podium and ask counsel, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial, but you're either right to be represented by counsel at your jury trial. You have a right to cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witness for yourself and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Okay. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I do not accept the Commonwealth's recommendation after hearing it and decide to impose a harsher punishment, you'll have a right to withdraw your plea and proceed with trial. Do you understand that?
Yes, sir.
Have you previously been convicted of a felony in the last 5 years?
Not that I know of, sir. No,
You would know it.
no,
Okay. Have you had any felonies in the last 10 years? I mean, you had any probation in the last 10 years? You're
no.
not on pretrial diversion now, are you? No. Okay, you understand if you complete the diversion program successfully, your case will be dismissed pretrial diverted, you can have your case expunged. You understand
Yes,
that?
sir.
Okay, do you understand that if you not fully complete your diversion successfully, you could be brought back to the court? If I avoid your pretrial diversion schedule a sentencing hearing, you'll be a convicted felon that could be used against you in the future. Do you understand
Yes, sir.
that? Mr. Stockton, will you come over here, sir? Will you all step to your left here? What's the Commonwealth's recommendation?
Your Honor, he will plead guilty to wanton endangerment first degree, receive a sentence of 5 years, serve 69 days in jail. I think he has that, with the balance pretrial diverted for 5 years supervised. He'll serve an additional 60 days home incarceration, with that being active prior to being released from incarceration. He'll obtain mental health evaluation and follow any and all recommendations, and that'll be conducted through probation and parole. He'll be referred to the SSC, follow all recommendations, receive credit for time served, and obtain gainful employment when he's released.
Is that your understanding of the Commonwealth's offer?
Yes, sir.
Okay, is anyone, including your attorney, threatened you or anything get you to enter this plea?
No, sir.
Are you entering the guilty plea because you did the acts that are charged in the indictment? You did the acts that you're charged with. You did what you're charged with.
Yes, sir.
Well, I mean,
You said yes, correct?
Yes, sir.
okay. You're pleading guilty of your own free will, is that correct?
Yes, sir.
And knowing your constitutional rights have explained it to you, is it still your desire to allow the court to fix your punishment? Is that your signature on there?
Yes, sir.
I accept the agreement and sign it. I will sign the diversion order. Now, when is he getting out?
My understanding, Your Honor, he can be released as soon as he gets the ankle monitor installed for home incarceration.
Okay. You still need to meet with probation and parole and talk to them. Commonwealth versus Aaron Southworth. Are you Aaron Southworth?
Yes, sir.
Good morning. You're here on 22 CR 0072 and 24 CR 0040. Mr. Southworth, were you born in 1992?
Yes, sir.
Last 4 digits, social security number 7202.
Yes, sir.
Do y'all have a plea agreement?
We don't have an agreement, Your Honor. My understanding is that we were going to get the negotiation and pretrial for next month, but set a trial date for after that.
When is the negotiation day?
It'd be August second.
Okay, if you're gonna go ahead and if you're confident you're gonna go ahead and set a trial date, why don't we just do that?
Your Honor, the intention was to get the negotiation and pretrial for next month and also get a trial date for after that in the event that we are not able to reach a resolution. We are still actively negotiating and believe that there is a possibility that we may be able to enter a plea in August.
This is the situation, Your Honor, this is a state where a lot of guns were stolen. Mr. Southworth defendant, Mr. Holland defendant, the victims basically said if those guns aren't recovered, they want a trial. So they can go to prison, have a chance to go to prison. I said, well, you get a trial. So I'm asking for a trial date on Mr. Southworth. And if we want to schedule a pre-trial, that's fine, but both of them know what they need to do.
I don't see the reason to schedule a pretrial or negotiation. Okay, let's get your calendar with you.
I do, Your Honor.
How many days? Can we try this in one day?
I don't think so. Mr. Davis is also represents Mr. Howland. And that's why we tried to get it. I don't think there's any proof.
I believe he's in custody. He is in custody.
Wasn't transported here today then? What's your client's name?
Nicholas Highland, sir.
He's where? He's in a Barron County jail, wasn't transported today. So we'll have him on the jail docket probably. We'll just wait till we call him, we'll set the same trial date, but while you're here, we'll get an agreement with you on the trial date.
Thank you.
Why don't you stay up here and bring your calendar with you?
Yes, sir.
Will Conwell versus Shirley be tried? How about August the 9th?
Tells me that the Russell case is going to other things now. Talk to witness about it.
Well, let's schedule it for this, yeah,
For August 13th?
yeah, or 14th, if you want a little longer to prepare.
Your Honor, I already have 1, 2, 3, 4, 5 cases scheduled for.
Which day?
On the 13th, I've got 2.
Are they for trials or what are they?
No, they're just for regular court dates down there. And I have DNA,
Well, I mean, where are they? What kind of court dates are they? If we could set a trial, surely you could get it. Are they arraignments or
Hardin County pretrial.
pre-trials? Well, why don't you consult and see if you can get the pre-trials moved to another day? Which one of the 13th or 14th would you prefer?
It doesn't matter, Your Honor.
Okay, well, let's just go ahead and do it on the 14th then, okay?
14th.
In Your Honor, we may have some motions before then. Should
I'll
we-
be glad, yeah, I'll be glad to give you a special schedule on those. Get a hold of my office and we'll give you a
Yes.
special schedule.
Thank you, Your Honor.
Yeah. Mhm. Skip that on all day, what is it? Well, this,
There's a couple people that were transferred, but I don't know. And you marked off Stacy Eden, you hadn't called her. That's one.
Conwell versus Stacy Eden. Are you Stacy Eden? Okay, good morning.
Right.
Okay, we're here on 23 CR 0051. What's your year of birth?
89,
Okay, and what's the last four digits social security number?
3,700.
You're here on the pretrial conference on 23 CR 0051.
Yes, we can have one more, Your Honor. We thought we had this case resolved, but I need to get the KCPC report. I've not gotten that for some reason.
August the 2nd for a negotiation date and August the 15th for your next trial date. Now, except for the paperwork on Hershel Hammer, do we have anything else?
He's at least in Barron County, and I'm not sure how he got this.
What's he got?
He's on the Barron.
Okay.
I just not.
Commonwealth versus David Buck.
The order was done.
Morning. Commonwealth versus David Buck, 24 CR 0017. Are you David Buck?
Yes, Your Honor.
Okay, you were born in 1982.
Yes,
Last four digits, social security number 2125.
yes, Your Honor.
You're on a pretrial conference.
Please, the court. Your Honor, we have asked, I believe we're going to ask the court for one more pretrial due to the fact that he's been in jail for about,
No, 4 days.
4 or 5 months, Judge, over a DUI. We got the results back from that day before yesterday, and it had 0 chemicals in it, alcohol or drugs. So I believe we're going to continue to try to negotiate the case.
What's you charged with?
He's charged with pointing down, bringing the lady. He was out on bond. He was charged with DUI. The court revoked his bond and incarcerated. And then this week, the test results come back, he had no drug or alcohol in his system. So I think the proper thing to do would be to put him out back on, but to reinstate the bond and set up another pretrial. If we can't resolve it, it's trial.
Is that okay with you?
Yes, sir.
I'll reinstate the bond. Have a negotiation day. You want to hear on negotiation day? On August the 2nd. Next court date on August the 15th. Now, what's your driver's license situation?
Trooper Tully still got them. I still got my license, but I ain't got, he took them away from when he pulled me over.
Well, you need to find out where they are. For him.
Yes.
Okay. Same conditions of bond you were previously on, okay?
All right, Your Honor.
Okay. Truman Adams. Mr. Stockton? Mr. Stockton, you and, ought to have your pic, you and defense counsel ought to, Mr. Bell ought to have your picture taken with Mr. Buck. He's the first 000 I've ever seen in 13 years, so it'd be a good photo op for both of you.
Well, he told me from the get.
Oh, I know, I don't care what he told you, I just offered you a picture, I don't want you to test, I have to swear you in if you testify.
I'm proud of it.
Truman, yeah, I'm sure you were, you know, Truman Adams. Truman Adams,
He's in Barron County, Your Honor.
You're on the Barron County.
yeah. I went down, because I marked Mr. Buck, I started down the same list. James Bristo. Excuse me. Commonwealth versus James Bristo, 24 CR 0033. Are you James Bristo?
Yes, sir.
Good morning. You born in 1990?
Yes, sir.
Last four digits, social security number 8640.
Yes.
We're here for a pretrial conference. What do you have?
It's a felony plea, Your Honor.
The motion's been tendered. It says you wish to enter a felony plea. Is that correct? Are you currently under the influence of drugs or alcohol? Are you currently under the influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person just identified in 24 CR 0033? Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Okay, have you viewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial, but a jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to call your own witnesses. The right to produce evidence. The right to appeal this matter to higher court if you lose. The right to part of the Commonwealth to prove beyond a reasonable doubt you're guilty of charge. You understand that by entering a guilty plea today, you give up those rights. Do you understand that? Okay, now I may consider the Commonwealth's recommendation, but I may play any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will look at a pre-sentence investigation report done by probation and parole. And then in the event I decide to impose a harsher sentence on you, you'll have the right to withdraw your plea and go to trial. You understand that?
Yes.
Step to the left, please, Mr. Stockton.
Yes, Mr. Bristo would plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years, probated for 5 years, supervised. He'll enter and complete the Monroe Specialty Program. All evidence in this case will be destroyed, and he'll obtain and maintain gainful employment, pay court costs, discretion of the court.
Now, what is your understanding? Is that your understanding of Commonwealth's recommendation? Yes. Okay, has anyone, including your attorney, offered you any other benefit other than that? Are you pleading guilty because you did commit the acts charged in the indictment? Are you doing so your own free will because you are guilty for no other reason? Knowing your constitutional rights, still your desire to waive those and allow the court to fix your punishment within a range permitted by law. You understand that by entering guilty plea today, any future convictions of felonies could be enhanced on the persistent felony offender law. Do you understand that? Is that your signature on there?
Yes, sir.
Yeah, I accept the agreement, order pre-sentence investigation report over sentencing on August 15th. What's the court cost in this case? $155. Do you need some time to pay that? $155. How much? 65. $165. I'll allow you to pay that at $30 a month. First payment being 30 days from today. Now, has he been voted into drug court yet?
No, that could be a sage.
Okay, he remains free until then? Okay, you under the same conditions of your bond that you have until you get assessed. Who does he need to see about that?
See Mr. Holland.
Okay, go meet with probation parole officer. Brockman Carter. Brockman Carter. Mr. Bell, are you entering an appearance in this case?
Yes, you are. Yes, Judge.
Commonwealth versus Brockman Carter, 24 CR 0030. You are Brockman Carter, born in 1983, last four digits, social security number 0829. Is that correct?
Yes, sir.
So we're here for a pretrial conference. What does the Commonwealth have on this case? Mr. Stockton, what do you have on the Brockman Carter case?
Mr. Bell said he wanted no more free trials.
Okay, let's have a negotiation day on August the 2nd and a pretrial on August the 15th, and we'll either settle it that day or we'll set you a speedy trial, okay?
Thank you, Judge.
Thank you very much. Richard Cornwell. Richard Cornwell. Commonwealth versus Richard Cornwell, 24 CR 0049. Are you Richard Cornwell?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last four digits, social security number 1976.
Yes, sir.
What does the Commonwealth have to say in this pretrial conference?
Your Honor, we're entering a guilty plea.
felony plea?
Yes,
Okay.
for probation.
Well, wait just a second, just hold your ground there.
Oh, I need to get the Commonwealth to sign the paperwork.
Okay,
Honest.
the motion's been tendered that says you wish to enter a plea today, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that just was identified in 24 CR 0049?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over them at the end of them. If you have any questions, you can ask your attorney. Okay. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at jury trial. Right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the Commonwealth to prove beyond a reasonable doubt you're guilty of charges against you. You understand that by entering this plea, you give up all those rights. You understand that?
Yes.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law if I do not accept the recommendation after having reviewed the pre-sentence investigation report. You have a right to withdraw your plea and proceed to a jury trial. Do you understand that?
Yes.
What's the Commonwealth's recommendation? Remove your left, sir.
Mr. Cornwell plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, probated for 5. He'll also plead guilty operating a motor vehicle under the influence, first offense, receive a $200 fine and cost. And he's currently in the Barron County Specialty Court and he will remain and complete that as a condition of this plea.
Okay.
He
You
also-
understand on your DUI too, that's enhanceable also. If you get another DUI, you could be charged with a higher penalty. You understand that? Okay. So this is what you agreed to, what Mr. Stockton just read. Is that correct?
Yes, sir.
You enter this plea because you did commit the acts that you're charged with.
Yes, sir.
Okay. Knowing your constitutional rights, that explains is still your desire to proceed with your plea of guilty and allow the court to fix your punishment within the range permitted by law.
Yes, sir.
You understand that various penalty and future convictions of felonies, like I said, I already told you, or the DUI could be enhanced, correct?
Yes, sir.
Is that your signature on the document?
Yes, sir.
Okay. I'll accept the plea agreement order pre-sentence investigation report and have sentencing for August the 15th. He should remain free on bond. He should remain free on bond, Mr. Stockton? Okay. Okay. May talk to probation parole officer over here. Isabella Costado. Gusto. I'll get it when she comes up here. Good morning. How do you say your last name?
Costado.
Costado, excuse me.
Yeah.
Commonwealth versus Isabel Costado, 24 CI 0052. Are you Isabel Costado?
Yes, sir.
Born in 2000.
Yes, sir.
Last 4 digits of social security number 5160.
Yes, sir.
Are you represented by counsel today? Okay. Have you filled an affidavit out to see if you're entitled to a public defender?
I haven't yet.
Oh,
Yes, Your Honor. She filled one out in district court. She has not filled one out in circuit
did
court.
you get a public defender in district court?
Yes, Your Honor.
I'll continue that appointment.
Yes, sir. Thank you, sir.
You're here today for the purpose of arraignment. You have a right to remain silent. You're represented by counsel. Who's appearing for the Commonwealth?
I am, Your Honor, Barbara Whaley, AG's office.
Okay. Got that volume turned up there, so that's good. Ms. Costado, you're charged of reckless driving. fleeing or evading the police, possession of marijuana, possession of drug paraphernalia, operating without a, or with expired license, wanton endangerment in the first degree, 3 counts. You understand those charges? Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we usually set a negotiation day with the Commonwealth meeting with the defendant. That negotiation day is set here for August the 2nd at 9 a.m. Is it meeting here, Mr. Stockton?
That's correct.
At 9 a.m.?
Yes.
Yes, it would be, the public advocate's office is usually here, so if y'all could have somebody here on August the 2nd to negotiate, and then the next pretrial will be August 15th.
I'm sorry, Your Honor, I have a conflict with August 2nd. Need to be in another county that day.
Yeah, well, I'm sure that they'll understand you not being there, because we all know Monroe County is the most important county. Okay, could you want to just work out something with, you got your calendar there with you? You have another day that you could do negotiation?
Your Honor, if we could get contact information for Miss Whaley, then,
If you'll just, Ms. White, if you'll just give the circuit clerk's office, email them your contact information, defense counsel will get directly in contact with you about a negotiation period, okay?
Thank you, Your Honor.
Your next court date will be August the 15th. August the 15th. Okay, well, thank you very much.
Thank
Yeah.
you.
Sydney Dyer. Commonwealth versus Sydney Dyer, 24 CR 0054. Are you Sydney Dyer?
Yes, sir.
What year were you born, Miss Dyer?
63,
The last 4 digits of the social security number 2471.
2171.
Okay, it's wrong on here. If y'all make note, it's wrong on the docket. I don't know. 2171. Okay. What does the Commonwealth have to say in the, oh, this is for a pretrial conference. What does the Commonwealth have to say in this case?
We have the pretrial version.
Okay, a motion has been filed. I've just been informed. It says you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes,
Are you the same person that was just identified?
yes, sir.
Okay. Is your judgment impaired today in any way? Have you discussed this charge with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? Do you believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. And I'll go over them at the end. You can, if you have any questions, step away and talk to your attorney, okay?
Yes,
You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury. Your right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence. Your right to call witnesses in your favor. Your right to appeal this matter to higher court. If you lose, the right to require the Commonwealth approval on a reasonable doubt that you're guilty charge against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply over any range of sentence provided by law. If I don't accept the recommendation and decide to impose a harsher sentence, you have to withdraw you can withdraw your guilty plea and proceed to trial. Now, I've been informed that this is a recommendation for pretrial diversion, so there's some qualifying questions I need to ask you. Have you previously been diverted in the last 5 years?
No, sir.
Any felonies in the past 10 years?
No.
Are you currently on probation or parole?
No, sir.
Okay, you understand that if you fully complete the diversion program, the charges will be dismissed pre-trial diversion. You can have your record expunged. You understand that if you do not successfully complete the diversion program, you'll be brought back before the court. If I revoke your pre-trial diversion, I'll schedule a hearing to be a convicted felon that can be used against you. You understand that?
Yes, sir.
If you step to your left, please, Mr. Stockton, what's the Commonwealth's recommendation?
Your Honor, Ms. Dyer will plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years supervised. She'll be referred to the Social Service Commission, follow all recommendations. She'll receive credit for time served, obtain or maintain gainful employment. All evidence in this case will be destroyed and she'll pay court costs at discretion of the court.
What is the court costing, please? $245. You need some time to pay that.
A little bit.
Okay, well, I'll give you, pay it $30 a month. The first payment will be 30 days from today, okay? I'll order I will sign the pretrial diversion agreement here. I'll accept it. Is that your signature?
Yes, sir.
You pleading guilty because you did commit the acts you're charged with?
Yes, sir.
Okay. Okay, I'll accept the agreement. You'll need to meet with a probation parole officer. Give them the information, okay? Connie England. Commonwealth versus Connie England, 24 CR 0024. Are you Connie England?
Yes, sir.
You born in 1959?
Yes, sir.
Last four digits, social security number 3930.
Yes, sir.
You're here today on a pretrial conference. What do y'all have?
Your Honor, we are entering a misdemeanor plea on this case.
Okay. A motion has been tendered, says you wish to enter plea today. Is that correct?
Yes, sir.
Yes. Are you currently under the influence of drugs or alcohol?
No, sir.
This is plea freely and voluntarily given.
Yes, sir.
Is the same person we just identified in the indictment?
Yes, sir.
Is your judgment impaired in any way today? Is your judgment impaired? Do you know what's
No,
going
sir.
on? Are you satisfied with the advice of your attorney?
Yes, sir.
Have you had plenty of time to review the evidence in your case?
Yes, sir.
Okay, you understand that you do not have to enter guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over the rights with you. And then at the end, I'm going to ask if you have any questions, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, the right to give us evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt you're guilty of charges against you, understand by entering this guilty plea. You give up those rights. Is that correct?
That's correct.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Now, this is a felony plea instead of a diversion.
It's a misdemeanor plea, Your Honor.
Misdemeanor plea. Okay, so we won't need a pre-sentence investigation report. Now, I want to hear what the Commonwealth's recommendation is. If you come around, Mr. Stockton, listen very carefully, man.
Yes, the charge will be amended to falsely report an incident. She'll receive a sentence of 12 months, probated for 2 years, unsupervised. She'll receive credit for any time served and pay court costs at discretion of the
What
court.
was the incident?
Evidently from a number, she called in and reported a kidnapping, and there was not a kidnapping. And so this is what I would.
Okay, are you pleading guilty, ma'am, because you did commit the acts charged in the indictment as amended? It's amended down to misdemeanor. So you did commit the acts you're charged with, is that correct?
Yes, sir.
Okay. Are you pleading of your own free will? Okay, I will know your constitutional rights. Is it still your desire to enter the plea and allow the court to fix the punishment?
Yes.
Now, is that your signature on the document?
Yes, sir.
Okay, what are the court costs in this case? You need some time to pay the $210. I'll allow you some time. You pay $30 a month, first payment 30 days from today, okay?
Yes, sir. I can pay the first of the month. It'd be better.
Well, you can pay whenever you want to, as long as it's within 30 days of
Yes, sir.
today, okay? And then you can line your own 30 days after that, okay? Okay, if you will go ahead and meet with the probation and parole officer, okay? Thank you. Sheldon Inns says there's an active warrant. Is that correct, Mr. Stockton? How do you pronounce his last name? Thank you. It's Jody Grace.
Your Honor, Lee Davis, I enter my appearance as conflict counsel for Mr. Grace.
Let me get him around here. Are you Jody Grace? Yes, sir. Good morning. This is 24 CR 0061. Mr. Grace, were you born in 1972? Yes, sir. Last four digits, social security number 6969. Yes, sir. Yeah, for pretrial conference.
Your Honor, I would ask for more pretrial conference, one more infinity, toward training to get that.
Okay, well, let's set a negotiation day for August the 2nd at 9 a.m. here. And your next court date, August the 15th. I don't have any complaints on your bond, so you can stay on the same bond. Both of these are requirements of your bond. Your attorney will be talking to you, okay?
Thank you.
Thank you. Shannon Maguire. Conwell versus Shannon Maguire. 24 CR 0045. Are you Shannon Maguire?
Yes, Your Honor.
You were born in 1986.
Yes.
Last four digits social security number are 5338.
Yes.
Here on a pretrial conference, what do we have?
Your Honor, we are entering a felony guilty plea for probation.
A motion has been tendered, as you just heard your counsel say, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes.
Are you the same person just identified as being indicted in 24 CR 0045?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, I have.
Have you viewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you fully understand your rights. I'm going to ask you at the end, you can affirm, okay?
Okay.
You have a right not to testify against you. No one can make you say anything. Your right to speak trial by jury, the right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea that you give up those.
Yes, Your Honor.
Now, we consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept any recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report from probation and parole. If then I do not accept the recommendation after reviewing that report and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
All those rights. Okay, let's step to the left here. Step to your left. Mr. Stockton, what is the Commonwealth's recommendation?
Mr. McGuire will plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years, probated for 5 years, supervised. She'll also plead guilty to operating a motor vehicle without insurance, $500 fine and costs. Plead guilty to endangering the welfare of a minor, receive a sentence of 12 months. Those two sentences shall run concurrently for a total of 3 years, probated for 5 years. She'll be referred to the SSC, follow all recommendations, obtain and maintain gainful employment, and pay court costs at discretion of the court.
There wasn't a DUI here.
No, there was not.
You want to step back over. Is that your understanding of the Commonwealth's recommendation?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Okay. Knowing your constitutional rights is still your desire to proceed and allow the court to fix your punishment. You understand that after entering a guilty plea, any future felony convictions could be enhanced as far as the range of penalty.
I do.
Is that your signature on that document?
Yes, sir, it is.
I'll accept the plea. The court costs will be how much?
240.
How much?
240.
Was there an insurance charge there?
$500, sir.
That has to be in there too, doesn't it?
It's a $500 fine then plus the court costs.
Yeah. Be $740 total. Is that right? We just add 500 to it, whatever you got. Okay. You'll need some time to pay that, I'm assuming. So I'll give you 30 days from today. You can pay it at $40 a month.
Okay.
Every 40 days. I'll schedule a pre-sentence investigation report, and your sentencing will be scheduled on August the 15th. Okay.
August 15th.
Meet with probation and parole officer. Diego Morales. Mr. Morales need an interpreter.
I've just got an email from his attorney,
Who is this attorney?
John Caudle. It says, I represent Mr. Morales. We had a court appearance this morning. I've just been released from the hospital and I thought my assistant had moved this hearing, but discovered this hasn't happened. We just received discovery yesterday, so I need time to go over with my client. If I can appear by Zoom, I can explain to the judge my phone number is. Send him a Zoom.
Send him a Zoom. Your attorney, had been ill, so we're going to send him a Zoom connection. So if you'll go back there, we'll call your case in a minute, Mr. Morales, okay? Just go back and have a seat in the crowd back there somewhere. We'll bring it back. Jody Murphy. Commonwealth of Kentucky versus Jody Murphy, 24 CR 0060. Are you Jody Murphy?
Yes, sir.
Born in 1999. Last four digits, social security is 6590.
Yes, sir.
Your day for pretrial conference. Ms. Murphy, if I gave you a drug test today, could you pass it?
Yes, sir.
Okay. I'll take your word for it. Are you just nervous or what's the deal?
Yeah, because I was late.
Pardon?
I was late getting here.
Okay, well, it's all right. I didn't know that until you confessed. So, you're here for a pretrial conference. What have y'all got?
Your Honor, Ms. Murphy is one of the numerous co-defendants in a case. I represent Dalton Birdwell in it. Because of that, she is a conflict to our office. We have staffed every one of the conflicts. We have this one lined up to be staffed. We are currently waiting on the contract to be signed. Once that is done, we can send the case and get the attorney in contact with Ms. Murphy. I expect that would be done within the next week. I apologize to the court that it was not done
She's
today.
already been arraigned, obviously. Okay, well, what I'm going to do is whoever your contract counsel is, you just need to have them here for negotiation on August the 2nd. And her next court appearance is August the 15th.
Yes, Your Honor, we will do so.
When Mr. Brown finds out who it is, tell us so we can send them a link and they get it scheduled.
Yes, we will do so.
Do you understand what's going on? They're going to appoint you another attorney, so you won't have a conflict. Commonwealth's going to send that attorney the evidence that they have to help prepare you for the trial. Then you're going to get with that attorney and together you'll be here on August the 2nd for negotiations and back here on August 15th for your next court date. Both of those are conditions of your bond. If you do not have counsel a few days before August the 2nd, you need to call and remind the public defender's office that the person has not contacted you, okay? You understand what I'm saying? Okay.
Mr. Morales' attorney is on the line.
Okay, we'll go back to Diego Morales.
Hello, Judge. This is John Caudle.
Okay, hold on just a second, Mr. Collin, and we'll call your client back up here. Commonwealth versus Diego Morales. 24 CR 0038. Are you Diego Morales?
Yes, sir.
Were you born in 1996?
Yes, sir.
Last four digits, social security number 5466.
Yes, sir.
Mr. Caudle is on the line here. He is your attorney. What does the Commonwealth have to say about this?
When we sent supplemental.
You don't come around where we can hear you.
We sent out supplemental discovery in the last couple of days.
And since Mr. Cottle's not here, I'd like to set this for one more pretrial on August the 2nd. If not,
Okay, well, on August the 2nd, Mr. Caudle, you and your client should be present here in Monroe County at 9 a.m. for a negotiation date. And the next court date will be August 15th. And Mr. Morales, after negotiation on August the 2nd, you'll either enter a plea or file further motions or set a trial date on the 15th. And both of those are conditions of your bond, okay?
Yes, Judge, we received discovery yesterday. I have reached out to the Commonwealth to settle the case since our last court appearance. Just to let you know, I'm not sleeping on the job here.
Okay, well, August the 2nd, you be present for negotiations. And then August the 15th is your next court date. Okay, Mr. Caudle?
Thank you.
Thank you, Mr. Morales. You may go.
thank you.
Ashley Pedigo. Conwell versus Ashley Pedigo, 24 CR 0046. Are you Ashley Pedigo? You born in 1991?
Yes, sir.
Last four digits of your social security number 1720.
Yeah.
You're on 24 CR 0046 for sentencing. Have you had an opportunity to look at pre-sentence investigation report done by probation and parole? Is it substantially correct?
Your Honor, there is some contact information that needs to be corrected. However, I will give that information to the
What kind
probation
of,
officer.
you don't have to say what kind of information.
Phone number and an address.
Okay, you probation parole officers over there, you can give it to them.
Can you talk with him? No.
On plea of guilty to possession of controlled substance, first degree methamphetamine, defendant shall receive 3 years probated for 5 years supervised. She shall be referred to social service conditions and following all recommendations, receive credit for time served, and all of this to be destroyed. What's the court cost or fines in this case?
$185.
$185. You need some time to pay that?
I've already paid a little bit on that.
Well, I'm gonna give you some time. If all you have, do you need some time to pay that? The answer would be yes. Okay, so I'll let you pay it at $30 a month. Make your first payment within 30 days of today, okay? Do it with probation parole officer over there. Conwell versus Pedigo, Michaela Pedigo. I don't know whether I'll ever get that out there, but Michaela. Conwell versus Michaela Pedigo, 24 CR 0049. Are you Miss Pedigo?
Yes, sir.
You were born in 1997?
Yes, sir.
Last four digits, social security number 0940. You're here for a pretrial conference.
That's correct, Your Honor.
What do you have?
I have Michaela Pedigo.
Yeah, well, what's going on?
Organized crime syndicate case over the stolen truck, and there's gonna be one more thing, more than likely after day, so I'd ask for another pretrial.
Okay, you want a negotiation day too?
Yeah, I'll have them all there one day.
Okay, August the 2nd, here at 9 AM for negotiation day. And August the 15th for the next court date, okay? Continue on your same bond, all right?
All right.
Yeah,
And Your Honor, that's all that I have for today, if I can be excused.
sure, have a great day.
Okay. Thank you, Your Honor.
Yeah. Jose Quano is Jose. Hey, pronounce your client's last name.
Quijano,
Quijano.
Quijano. Yes, sir.
Jose Quijano. Are you Jose Quijano?
Yes.
You born in 1984? Last four, you don't have a social security number. You are here today on 24 CR 0031 for a pretrial conference. You're represented by Mr. Bell. What does the Commonwealth have to say in Mr. Quijano's
Your Honor, we
case?
discussed this at the last negotiation day. My office then reached out to the officer involved in this. If we can't resolve it, one more negotiation day, I'll ask for.
What is the charge?
Bribery and terrorist threat.
Bribery.
That's the only felony is bribery, judges. I think we got it resolved. The terroristic threat is what's holding us up.
Well, that's an odd combination of charges there, I would say. So
Sometimes you're intoxicated, you say things you shouldn't say.
I wouldn't know, but I'll take your word for it.
Well, I would agree.
Okay, we'll set this for a negotiation day on August the 2nd, and your next court date is August the 15th. You're on the same bond conditions, okay?
Thank you.
Jonathan Russell. Are you Jonathan Russell? Good morning. This is 24 CR 0018 and 23 CR 0012. Motions in limine. You want to proceed, Mr.
I would like to address another issue if the court would allow me to.
Of course.
Judge, we have a officer that Mr. Hunley made me aware of that can't be present for the trial. He was the first officer on scene and rode in the ambulance with the alleged victim in the case. We feel that's an indispensable witness, and we would ask the court to grant us a continuance.
When is the
until
trial set for?
August 13th.
Excuse me. What does the Commonwealth have to say about that?
We only found out about this last week, maybe the first part of this week. And this witness, Harold Brown, who was the police chief at Fountain Run, he was the first officer on the scene. I think he would be indispensable to both the defense and the Commonwealth.
Yeah, is he going to just be out of town that day, or what's the deal?
We, about 10 days ago, served everybody involved with subpoenas. Mr. Brown received his subpoena and called our office. And that he and his wife, who was also subpoenaed in the trial, she's an EMT, had planned a vacation months ago.
Okay, that's it. I just wondered if he would be available in the future.
I'm sure he will.
Do y'all have your calendars out? We can go ahead and set it for another day.
If you want to do a negotiation day too, or just.
Well, you wouldn't ever negotiate, you won't negotiate.
Okay.
That's new.
I mean, it's over. Right, let's just set a trial date.
Okay. Let's see here. Wonder how long he's gonna be gone, you know?
I do not, guys.
Yeah. So the next week probably still be a little chancy, wouldn't it?
I would think so.
Yeah. How about August the 4th?
Originally had it set for 2 days.
What is the trial about?
It's about a shooting and tampering with evidence.
Think you can do it in one day?
No, sir.
Okay. Then we can't do it on the 4th. How about Harbor and Perigin over in Clinton County? Will it go?
I have anything to do with it, it's gonna be friendly.
Well, you do have something to do with it.
If it's in my control, it's gonna be right.
It's not within your control, but you do have something to do with it.
Yeah, I follow the track.
Okay, all right. Now on the 16th, 17th, and 18th, we have Monroe County Commonwealth versus Robles. Here in Monroe.
September, I believe.
I will tell the court on that case, there is some items that's been sent to agency. And they've been up there for a long time. They were trying to talk to the lab person. And he's assured me.
17, 18, perfect.
By the first month, that might be a problem.
At 16, 17, 18, perfect for me, Judge. I don't.
Well, they've got another trial scheduled here.
Yes, sir.
Do you think that Robles case is gonna take 3 days, Mr. Stockton?
What's that, Your Honor?
Robles case will take 3 days.
I would think too. Depends on Mr. Gary, how long it's taking. On your witnesses.
Let's schedule this trial here for the 17th. And then we can go over to the 18th also. What?
So you're gonna try the Robles in one day?
No, I'm gonna tell them that we'll schedule it for the 17th and we can start out in the afternoon. sitting a jury and stuff, if you think this one might take more than 1 day, do you?
Yes, sir. I believe it's
So I
two
think
or
we
three.
agree both. Well, let's just schedule it for the 17th. And if something happens, we can reschedule the trial.
September 17th
Yeah, and 18th.
and 18th.
Okay, now what about your motions in limine?
Judge, I filed mine last week. They filed theirs last week or this week. I don't know which one we done. I view the fact that we got a little more time. I'd like to look into it a little closer and maybe make a little more informed argument concerning the issue.
Well, we're all about informed arguments. I'm all about that.
I mean, I believe mine has merit, but I don't know about theirs.
Yeah, it happens. What kind of motion? What do you want to limit?
I'm sorry,
What do
Judge.
you want to limit?
Judge, they were wanting to introduce the firearms on a other indictment. We did get a court order stating that you were going to join those. They brought that up at the last time we had court. I wanted to reserve that to be able to look into it. It's my position, Judge, that the allegations in the charges concerning Mr. Russell involve a pistol. That's the allegations. They have gotten people to testify that some long guns was removed from his house. They are in turn trying to state that because he had a DVO in Allen County, that was tampering with physical evidence. But of course, I mean, the court understands the tampering law. There was no motions or any notice given to him that he had violated the EPO. So there wasn't a proceeding that was even pending, and the firearms that were taken from the house are not relevant in any shape, fashion, or form pursuant to the allegations that they brought forth in their charge. So
I don't understand. You said he had a DVO, wasn't supposed to have any guns there, but they say he had guns there. Then they say they removed the guns, and that's how they charge him with tampering. Is that correct?
That's correct.
Is that right?
that's right. But
But I'm not following your argument.
okay, there was no notice given to Mr. Russell.
What kind of notice do you have to give to somebody? if
Well, you have to give
can't-
somebody notice on a violation of a.
Well, I mean-
EPO and have a hearing on
This
that.
isn't, that, they would on that EPO, I guess, but this is not a part of the EPO. This is a
That's my
separate
point.
criminal, this is a criminal charge here.
That's my point.
I
But in
don't get
order,
your, well, make your point simpler, get behind the podium so even I can understand it.
on tampering, you know, you mutilate, move, destroy evidentiary matter that you know could be used in some crime against you. There is no crime against him because he wasn't given any notice concerning any violation. The guns that they're stating he removed, if you look at it in the context of the charges that's been brought against him, weren't relevant because they weren't the guns that were alleged to be used in this shooting. It was a pistol, and there's nothing within the evidentiary matter that says that a pistol was removed. So there was no pending criminal charge against my client at the time that those guns were removed, therefore it can't
Let
be
me
taken
ask
from
you
physical
something.
evidence.
If somebody has an EPO against them and some officers come there and the person removes the weapons and because they know they've got an EPO, would that qualify? You're saying that wouldn't qualify for a tampering charge?
I'm saying that, no, I
I'm
don't
just
think
asking.
it would,
Okay, well, I just
Yeah.
wanted to understand your position.
but I think he would
What do you
be,
have to say, Mr. Truman?
I think that Mr. Bell is wanting to testify here today, Your Honor. It sounds to me like the issues
But
he's
don't
raising.
worry, you wait till well, this way you hold him to what he says at the trial.
Judge, maybe I can explain this case in more simple terms. Mr. Russell is charged with a shooting that occurred on January of 2022. At that time, he was charged with assault first, and he was indicted on violation of Kentucky DVO order arising out from Allen County, Kentucky. Subsequently, Commonwealth, as it investigated this case, found evidence that some of the witnesses that had told the officers that they hadn't been there and they didn't remove any guns have recanted. And there will be specific testimony that as soon as this shooting took place and the victim left, that Mr. Russell called a neighbor, next door neighbor, to come over there. The neighbor came, that Mr. Russell told him that he had an existing EPO out of Allen County and that she was going to call the law. That's the victim he's referring to. And that he had these weapons and he gave them 5 long guns that they took from the scene. That's exactly what the proof will show.
And you believe that that's tampering? I'm just asking.
Yes,
I'm just asking, and that's what y'all grand jury charged him with tampering.
He could say
Is that what you're charging with tampering on those acts?
Yes, it is.
Okay. Do you have anything to say in response to that?
Judge, I mean, I guess my testimony was given to Mr. Huntley's testimony. I mean, some of those facts I would dispute. Simplistically, I would state there was no charge brought against my client at the time. Concerning those firearms, there was nothing pending. There was nothing brought forth. There was no knowledge of any type of action
Well,
against him.
here's
Therefore, it
the
can't be
thing.
tampered.
Here's the thing about it. I really haven't ever faced anything exactly like this. I mean, the fella, according to the testimony, acknowledges the fact that he has a domestic violence order against him, that the person who is the protected person is going to report him.
Well, according to Mr. Hunt.
Well,
as I've said,
well,
this is an evidentiary matter.
all of these are just accusations.
That's true.
Mr. Huntley's not under oath, and we don't know what those people might say, but that's the Commonwealth's case. So he's gone next door and acknowledged that he's got a DVO, and then he gets somebody to remove to help him hide some long guns because he knows that she's going to prosecute the case. I think it's I'll take it under advisement, but I think I'm leaning toward allowing it in. And what's your other motion in limine?
Judge, I will state that in conclusion, I do have some case law on that if the court will permit me to.
Absolutely, I'll allow you to brief it. And then Mr. Huntley, if after he sees your piece of work, will have an opportunity to reply to it.
Thank you, Judge.
Okay, now what's your other motion in limine?
I didn't have any. The Commonwealth filed a 404B notice.
Okay, what's your 404B, Mr. Huntley?
Well, Judge, as a matter of defensive practice, we are requesting that the court enter that order from the Allen District Court establishing the DVO. And in that order, it expressly states that the defendant shall have no firearms at his house, that he can't live in a house where there are firearms.
What have you charged him here with besides?
He's charged with tampering with physical evidence. He's charged, let's back it up.
First,
chronologically, he's charged with assault 1, violation of the Kentucky DBO out of Allen County.
Yeah.
And then months later, the evidence came forward and he was subsequently indicted.
So the DBO is not a separate bad act. It's part of part of the elements that's necessary. So you don't have any objection to that, do you?
Well, I do, Judge, because what he wrote in his motion was is that he was wanting to bring in all of the different allegations concerning the DBO. If they just want to say there was a DBO pending against him, I don't have any objection against that. But if they try to get up here, and I believe they will, describe
other bad acts.
Right.
Okay, well, those 404B are other bad acts that not only are just testified about like you can, but it looks like to me there's been a ruling in the court that they occurred. So I don't see anything. If it's the same victim, the same perpetrator, and is that correct?
Yes.
Okay, well.
And I filed this 404B notice.
Well, wait a second. What relevance does any 404B have? You have to make a determination that you have the same perpetrator, the same victim, that they've done that sort of thing in the past. This person, that's what 404B are quite frequently. And you can file a brief on that if you want to, and I'll take a look at it. And you have anything else?
Just briefly, Your Honor, the reason I filed this 404B notion relating to the order out of Allen County was, I knew Mr. Bell would take that stance. So I wanted to dispose of it here today.
Well, you have an opportunity to brief that to me.
No, they had another issue, Judge. They're wanting to file a motion in limine concerning the victim in this case being high on methamphetamine, marijuana, amphetamines. They're not wanting us to be able to, well, I'll let him argue his motion if he knows.
Well, you're doing a pretty good job. It might, you ought to get 1 for 3 today anyway.
I'll take a free one, Judge.
What's your motion gonna be as far as the?
Your Honor, we are moving to exclude any testimony during the trial of the case of a drug test that was administered to the victim the night of the incident at the T.J. Sampson Hospital.
What do you think the relevance that is?
Well, Judge, our defense is going to be that she drove up to his house. She drove into his house 2 different occasions, kicked the door in and come in and attacked him. And she ended up shot. So, the fact that she was high on methamphetamine and other drugs.
I think that should be admissible.
Well, Your Honor, the primary reason is that the test administered by T.J. Sampson was a urine test. The hospital records state that this test provides only unconfirmed screening test results. Both false positive and false negative results may occur. This specimen was received without chain of custody and may not have been handled as a legal specimen. Results should be used for medical purposes only and not for any legal or employment evaluation program. The documents provided in there.
What did it show? What did the test show?
It showed positive for amphetamines and methamphetamines.
Just positive. It didn't quantify them in any way.
It's less than the minimum amount.
Are you going to have an expert witness to testify what effect that this amount of those drugs would have on somebody?
We could, Judge. I mean, at this point, the only thing I want her to do if she testifies, which she's going to have to testify, is be able to ask her, were you under the influence that day and what were you under the influence of? If she says she was high and what she was under the influence, we don't have no need for it. If she lies about it.
Well, she wouldn't have to say she was high. You could ask her if she consumed any. She could say, yes, I consumed some, then that wouldn't be necessary to you want to use this to impeach her.
If she lies about being.
Well, if she you would need it to impeach her if it agreed with what the test was.
Right. So that would be correct, Judge. I would just like for the jury to have a clear understanding of what took place here and come up with.
Well, I know what you want, but here's the thing about it is I will allow that to be used for the purpose of impeachment. Okay. And so if you ask her if she had taken some drugs that day, she can say that she did, then you couldn't impeach her on it in that situation. You
We can ask her what kind of drugs, Judge?
I don't see why that would be harmful had you had any someone on it and were you under the influence. Now, if she says she wasn't under the influence, unless you bring an expert witness that says that amount with her body size and that sort of thing would make a person under the influence, and you can't ask her about being under the influence.
Well, that's my point, Judge. It's not a quantitative amount. It's just that it was more than a certain amount, and if it had been less than a certain amount.
Then the expert witness will testify that from that test they can't testify, and I won't let them testify.
And you're speaking on the influence as far as us.
Then my big problem on this case is there's going to be a bushel full of hearsay evidence that's going to try to put her in a place where she got methamphetamine. One of the witnesses at the scene told the officer, oh, she's just a meth head. She's just wild crazy. He wasn't even there. They said, element after element of hearsay testimony.
Well, that doesn't have anything to do with this, you know, so.
I'm thinking that the hospital records themselves basically are saying this is not a legal test.
Well, that's what they do to cover themselves there. If you had that test and you were prosecuting a case, you'd say that that was on there as boilerplate.
That's possible, Judge.
And what I'm saying is it's boilerplate and you, the goose and the gander, and this time you're the gander.
Oh, I've been that before.
Okay,
So,
all right.
Thank you,
Those
Judge.
charges consolidated.
yes. Now,
Yeah, the judge did.
I will concede a part of Mr. Bale's motion, Your Honor. The indictment improperly stated that he was concealing the weapon used in the shooting, and that we have no proof that weapon was never found. The indictment should be amended to reflect that. The indictment also charges that he was there and to remove from the scene firearms possessed by him in contravention of a existing DVO.
Judge, and
So
that's
it's-
a very different charge than tampering with physical evidence. We would agree that they have the right to bring that, but they're trying to use it for, I mean, it could be some type of.
Well, if he had guns there in violation of an EPO, that's a crime, isn't it?
It is, but.
Well, that's what they've
misdemeanor.
charged him with.
It is a misdemeanor. I'm not saying
Well,
that
it's
it's,
doing the same thing to bring the tampering with physical evidence.
but when he had his neighbor come over to pick the guns, he turned the misdemeanor into a Class D felony, Your Honor.
I believe that's true, if they can prove that. Okay. Y'all don't need it. What date is it set for? We just set it for,
17th and 18th, Judge.
we still good?
Yes.
Okay, thank y'all.
Thank you, Your Honor.
Gerald Ryan. For arraignment. Commonwealth of Kentucky versus Gerald Ryan, 24 CR 0065. Are you Gerald Ryan? Okay, you have the right to remain silent. You're here for arraignment. You have your attorney with you. If you have any questions, step away from the podium and ask him. The grand jury of Monroe County has charged you with sodomy in the 3rd degree, rape in the 3rd degree, and incest. You understand what those charges are, don't you? Okay. Mr. Garrett, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
I do, Your Honor.
I'm signing a reciprocal discovery order that requires the Commonwealth to give you all the evidence they have. Is it too soon for a negotiation day, or you?
No, we can say them out.
August the 2nd for negotiation day, your next court date will be August the 15th. Now, the condition of bond is to stay away from the alleged victim, is that correct? Hello,
It is.
she over there?
Oh, I'm sorry, Your Honor, I didn't realize. Yes.
Okay, thank you. We'll make sure you stay away from the alleged victim.
Judge, on August 15th, I've got a trial in Adair County that is likely to go, but if it does, or if it looks like it's going to go, I'll let the Commonwealth know. But I'm
We'll
just,
move you to another county if that happens.
okay, thank you, Judge.
Okay, Chad Shirley. Commonwealth versus Chad Shirley, 24 CI 0029. Are you Chad Shirley?
Sir.
Were you born in 1990?
Yes, sir.
Last four digits, social security number 4625. You're here for a pretrial conference. What do we have, Mr. Bell?
Your Honor, we don't have an agreement yet. I would like if the court would allow Ms. Evelyn Shirley Pride and set this for the September motion day with the negotiation on September the sixth, if that would be all right.
September the 6th, here at 9 a.m.
Yes.
And the next court date is September the 12th. September the 6th at 9 a.m. for negotiation, and September 12th for your next court date, okay? Angela Smith.
See,
Angela Smith. Commonwealth versus Angela Smith, 24 CR 0051. Are you Angela Smith?
Yes, sir.
You born in 1975? Mr. Bell,
sir.
let her in there at the microphone.
sorry, Judge.
Last four digits of social security number 4112.
Yes, sir.
You're on 24 CR 0051 for a pretrial conference. What does the Commonwealth have to say?
I believe we have an agreement, so we can just pass it so we can get the paperwork done when we're talks.
Okay, you don't need a negotiation day?
Yeah, she appear on negotiation day, get the paperwork.
August the 2nd, you be here at 9 a.m. The next court date is August 15th. Both of those are part of your bond. Do you understand that?
What now?
Both of those are part of your.
August the 2nd at 9 a.m. to come sign your papers and negotiate. And August 15th is your next court date, okay?
Thank you.
Christopher Stillwell. Let me finish the call of these four cases, and then before I go to Barron County, we'll do that, okay? Commonwealth versus Christopher Stillwell, 24 CR 0012. Are you Christopher Stillwell?
Yes, sir.
You born in 1975?
Yes, sir.
Last four digits, social security number 6497.
Yes, sir.
We're here for a pretrial conference and an arraignment. You have.
It's the same case, Judge. There were just two charges added on. He's already been arraigned on one of the charges.
Okay.
Problem, same moment.
This is a superseding indictment, is that correct? And this is 24 CR 00012, and you're adding trafficking and controlled substance and PFO, or just PFO in it?
Both.
Both, okay. In addition to the charges previously arraigned, you would be charged with traffic controlled substance first degree, being a persistent felony offender in just one charge of PFO him on one charge, or two charges, looks like.
Should just be one because the other charges are possession.
Okay. You need to look at the indictment very closely on that, okay?
Yes, sir, Judge.
Okay, you have a negotiation day on this? Negotiation day on August the 2nd, and the next court date is on August 15th. Both of them are conditions your bond. Christopher Sutton. Christopher Sutton. Commonwealth versus Christopher Sutton, 24 CR 007. You are Christopher Sutton, born in 1995. Last four digits, social security number 1321. You're on a pretrial conference. What does the Commonwealth have to say?
We have a felony plea.
It's a diversion plea.
Verdict, I'm sorry.
I understand, sir, that you wish to enter a plea today. Is that correct? Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely involved in material given?
Yes.
Are you the same person that was just identified in 24 CR 0007?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? You believe that you're fully informed about your case?
Yes.
Okay. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I need to know that you fully understand those rights before I can accept a plea. And I'm going to ask you at the end of going over if you understand. If you don't, you can step away and talk to your attorney. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence. Your right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the comment to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that? And a guilty plea today, you give up those rights. You understand it? Now, I may consider the Commonwealth's recommendation, but I may apply any range sentence allowed by law. And if I don't accept the recommendation, decide to impose a harsher punishment, you have a right to withdraw your plea and proceed to trial. Now, I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Do you have any felonies in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you complete the diversion program, the charges will be dismissed, pretrial diverted, and you can have your record expunged. You understand if you don't successfully complete it, you brought back in front of me that I avoid your pretrial diversion, all the pre-sentence investigation report says that you'll be a convicted felon, and that could be used against you to enhance sentences in the future. Do you understand that? Mr. Stockton, will you come around and announce what the Commonwealth's position is?
Yeah, Your Honor, Mr.
Sutton will plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years to serve. He'll also plead guilty to theft by unlawful taking over $1,000, receive a sentence of 5 years to serve. They'll run consecutively for a total of 8 years. Pretrial diverted for 5 years. Diversions to be supervised. The defendant shall receive credit for time served, which is 162 days as of July 17th of this year. He'll pay court costs at the discretion of the court, agrees to be assessed and complete any recommendations of the SSC. He'll obtain and maintain gainful employment. He'll forfeit the 9mm firearm that was in his possession, and all evidence in this case will be destroyed.
Come back and tell me about the firearm again.
Case where Mr.
Sutton was hooked up to a trailer and lumber that belonged to Wayne Peak, who I spoke with yesterday. And when the law was called and they inquired about him being in possession of the lumber and the trailer, they found on him a 9mm pistol with methamphetamine up in the butt of the gun.
Jeez.
And so that's the reason for the SSC. And the only reason I'm doing this plea is because he's got 162 days in. And he's not a convicted felon, or I would have charged him with that.
He's got 8 years hanging over his head. It'll be up to him whether he makes.
Is that your understanding of the Commonwealth's recommendation?
Yes.
Has anyone threatened you over this?
No.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
Are you doing so of your own free will?
Yes.
Knowing your constitutional rights, is it still your desire to give up those rights, enter plead guilty, and allow the court to fix your punishment? Is that your signature on there?
Yes.
Now, before I accept this agreement, put it over there, I want to have a straight talk with you. If I, during this term of your pretrial diversion, even smell any kind of activity with drugs on you that's brought up here, or if you have a weapon on you, you're getting a real break here. Out having a gun with methamphetamine in it? Are you kidding me? What? I'm not going to ask you, this is a rhetorical question. What were you thinking, man? You know, you got a real chance here to work your way out of this thing and have a normal life. But there are a lot of people that are in federal jail that have a weapon and drugs on them like that because they say you were using a drug in a commission of a felony. So, you know, you must be living under a good star or something like that, but you're not going to get any slack from me. I give people slack and I'm not being disrespectful to you. Okay. I'm just telling you the way it is. Do you understand me? Are we straight on that? Okay. Okay. You go over, what's the court cost?
$315.
$315. You need some time to pay that?
Yes, please.
I'll let you pay it $50 a month. The first payment's going to be made 30 days from today, and go over and meet with the probation and parole officer. Okay, Benjamin Tully.
Judge, he still has an ankle monitor on. I'm assuming that can be taken off now.
That's found me. Won't be drug tested.
It'll be fine. Benjamin Tully. Conwell versus Benjamin Tully.
Judge, I believe we passed this out, a long ways, and I don't know why it's back on the docket today, but we had done that last time, but.
That was 9-10. I can try, you got a possession case, I can try, revoke it, but I'm waiting on the case in Hamilton County to see who's the bishop. Because the reports I get to Mr. Collins working, it's not helping the problem.
September 12th.
Thank you, Judge.
Back September 12th. Brandon Walden. Brandon Walden.
Dismissed, diverted.
Dismissed, diverted. Does the Commonwealth have anything to say about that? Then there's another case that was not Noah Freeman. Let me get up here first. Commonwealth versus Noah Freeman, 22 CR 0034 and 22 CR 0062. Are you Noah O. Freeman?
Yes, Your Honor.
Born in 1981.
Yes,
Last
Your
four digits, Social Security 1932. Now, what do you want to do with this, Mr. Stocks?
I said till the August rule date, that's all I told.
Okay,
Personal injury.
August 15th.
You free to go?
Yes, absolutely.
You know.
Now, we have, I know the grand jury's ready, but we have, St. Petersburg, Federal Correctional Institution, someone on there.
That's Josh Vincent, Your Honor.
Okay, but
One we do every month.
well, I don't see him on there. Is it Joshua Donahue? Is that his phone or whose phone is this? If you're on there and you're in St. Petersburg or Petersburg Federal Institution of Correction, turn your camera on. Do you know who that is on there, Mr.?
Josh Vincent is the one, Judge. I talked to him this morning. We've talked to him quite a bit this week.
Well, maybe we need it on next month because Mr. Bell gave my staff during court some paperwork, it got misplaced. I didn't have it now, so I can go.
Will you inform him that he's to be on here? And if you'll give a time certain, next time I'll have him at the time. We've run over. He might have, I guess he's got free movement there. So let's set him for August the 15th at 9 a.m. Central Time. And we'll take him first, okay?
And you know, if I could just briefly say, he's getting pretty upset with me, asking me to set a trial in his case. I do think we're supposed to get it straightened out.
How can we set a trial?
Well, I'm just in a bad position myself. You know, I've got responsibilities to him also.
Well, you want to arraign him next
Well,
time?
he can blame me because
I don't care who he blames.
I'm not really looking to blame
me, I'm
anybody.
old, so.
I didn't know Mr. Bell had the paperwork, right? He couldn't do it last month.
Yes, sir.
Okay, well, is he going to enter a plea?
No, Mr. Bell's one case dismissed. And,
I'm just wanting him out to
he's
get
furnished me some
treatment.
information I need to go over with the victim. And I've just not been able to do it.
This is one, Judge, we,
I remember.
Yeah.
Yeah.
yeah,
He
I
hasn't
mean,
been right.
Yes, well,
I didn't
now
want to say
he's
you right.
here for a trial.
that's what I'd hope for.
Well, the feds don't want to let him loose for a trial, do they?
No, sir, they don't want to let him loose for anything. And the only thing we've been trying to achieve, as the court well knows, is get him out to get him treatment because, you know, it's our
See,
position.
that's not our deal here.
I understand. Well,
And do you have anything from the feds in writing is that they're holding because of this? It'd be good if you got us something in writing.
I have provided
I
information.
just asked you if you had it. I'm not asking what you provided. Do you have something
Yeah,
from a U.S. attorney or from the Federal Department of Corrections to say that they're holding him because of this charge, or he can't get treated because of this charge? It must be like you say to me all the time, simple, so even I can understand it, okay?
Yes, sir.
Because I know Mr. Stockton can understand it if I can understand it. Okay? Thank you very much.
Thank you.
Now, I'm gonna be in Barron County just for a second, but first the grand jury's coming in. Counselor, y'all wanna move over here while the grand jury comes in? And then Barron County will be right with you. Oh. All rise for the grand jury, please. Everyone can be seated. Who's the foreperson of the grand jury? Mr. Foreman, have y'all completed your work?
We have.
Have 9 or more of you agreed on all the documents you have in your hand?
We did.
You proceeded, if you present it to the bailiff here and you can have a seat. Thank you. I've examined the document and it appears to be in order. We'll take these indictments, ladies and gentlemen, the jury will review them and set them with bonds that are sufficient to assure their attendance here at court and or if they're a danger to assure that we secure them to protect the public. In addition to that, there could be someone, one or more people who are already incarcerated. If they are, we'll issue summons on them, or if there's other indictments that involve the same activity, we'll issue summons if they haven't acted out on the same bonds. I want to remind you that each one of you took an oath to keep the matters that you're considering confidential. It's crucial that you do that, okay? Because sometimes, as my grandfather used to say, people decide they're going to get scarce. If they find out they've been indicted, and they might flee, or they might cause some harm to a potential witness. So all of you understand that. I would also admonish you that if anybody tries to contact you to influence you in any way because they know you're members of the grand jury, that you should immediately report that to the Commonwealth Attorney's Office or the Sheriff's Department, who will contact me and we'll take care of that, okay? Thank you very much. The next date that y'all are to come back is August the 15th, and quite frankly, I can't even believe it's already August. I'm just now getting used to writing 2024, but it's August. But the good thing about it, we're getting near football season. That's the great thing about it. Okay, so y'all be excused. Thank you for your service, unless you're called back in on special session because of riot or insurrection. And as I told you probably last time, these days you can't ever tell when you might have a riot or insurrection. So we'll see you here on August the 15th. All rise for the grand jury, please. There you go. Y'all may go out there. Thank you. Okay, y'all can be seated, everybody. Let's go to the Barron County Correctional Institution. or the detention center? Truman Adams. Conwell versus Truman Adams, 24 CR 0057. Are you Truman Adams?
Yes, sir.
Were you born in 1968?
Yes, sir.
Last four digits of your social security in 1550.
Yeah.
You're on a pretrial conference. What do we have?
You know, there should be another indictment on Mr. Adams in today's grand jury, so we can have one more pre-trial. And,
Let's set a negotiation day for August the 2nd and the next court appearance for August the 15th.
Yes, sir. Thank you.
Your attorney will be over to see you, Mr. Adams. Jonathan Brown. Are you Jonathan Brown?
Yes, sir.
Mr. Bell, could you kind of go over to your left a little bit? This camera here is not working, and I have to use that camera back
Yes,
there.
sir.
Thank you. And you know, it's always been dangerous to get between me and the camera. Okay, Mr. Bell, were you born in 1976?
Yes, sir.
Last four digits of social security 0306.
Yes, sir.
You got two motions for shock probation. What do you have?
Judge, Mr. Brown has been incarcerated, I
What's
believe.
the underlying charges, do you want?
This was a trafficking charge, Your Honor. And methamphetamine. We had entered a plea on him, of course, and made a motion for probation at that time, which was not successful. Your Honor, Mr. Brown is doing very well in custody. He's working. He's out on the road crew. He's working in the kitchen. He's doing the things that he needs to do. He's trying to take any classes or anything that's available to him. And Judge, he has a business that
What was
he
the quantity involved, Mr. Stalker?
When I get my turn,
It's your turn.
That's what Vicky said.
It's your turn. I understand.
Thank you for the full picture.
Well, I was getting a preliminary picture.
In 21 CR 111, Your Honor, Mr. Brown was charged with T-butt and trafficking. He had a 6-year sentence, served 120 days. He had 31 grams of meth at that time. That $5,000 fine.
Go ahead.
Okay. Then in 23 CR 64, that was the new case he picked up while he was on probation. He was charged with trafficking and PFO. He also was charged with convicted felon possession of a firearm. So he had the firearm and 62 grams of meth with him that time.
Second time?
Second time. I gave him 4 years consecutive, which made a total of 10 years, and dismissed the PFO. And so he's serving a 10-year sentence. He will, I think he's got about 6 months. I can't remember the time in, but he's parole eligible. When was it, Mr. Collins? I don't have the file out.
But I can't in good conscience go along and when we did the offer the last time,
Come back over here.
when I agreed to the 4 years, I put it in the Commonwealth's offer that the Commonwealth will be opposed to probation and shock probation. I think you got a very lenient deal with you added up, it's 90-some grams between the two cases. Plus the second time he had the handgun. So he doesn't need to be out on shock probation is the Commonwealth's opinion.
I'd like to finish my argument, Judge, anyway. And I won't get into a lot of legalese about this situation, but I will say, Judge, it's my position that methamphetamine now costs approximately $200 to $300 an ounce. It's cheaper than groceries. And if you're an addict and you go pick up methamphetamine, you're going to pick up an amount that's going to do you for a while. And if you're an addict, an ounce of methamphetamine is not going to do you for very long.
Well, wait a second. I don't have any proof in front of me about that.
Well, I mean,
you know, and I can't take judicial notice of things. if you just tell me that the quantity was the amount that you believe should have been or could have been used for his personal use.
That's it, Judge.
Okay, that's enough. I don't want any.
And if I may conclude, one last thing, Judge, when
Give
Mr.
you plenty of time. Go ahead.
When Mr. Brown went into custody, his attitude was difficult at a lot of stages. Since he has been in custody this amount of time, he has completely
I have no
changed.
testimony to that fact.
I mean, Judge, I don't know how to get someone to testify about their attitude changing. I mean, I guess I could put Mr. Brown on and let him try to testify to that,
Well,
but that,
I am not inclined because of 2 trafficking charges and a weapon on the second charge and the very lenient break he got on it to shock probate him. Now, I'm just not inclined to do that. You know how I feel about weapons and people, but I know, I tell you, I take judicial notice of the fact if you have that amount of methamphetamine on it, you probably ought to have a gun with you. You know,
Well, I
because
mean-
somebody will rob you, you know, somebody will take, you know, it's dangerous. But he pled guilty to these things
I
and
understand.
he had a
Judge.
weapon. Okay, thank you very much.
Thank you, Judge.
The next case up is Keith Gross. Keith Gross.
Your Honor, may I speak, Your Honor?
No. Keith Gross. Keith Gross.
Andrew Rhodes from DPA, Mr. Rhodes.
Cromwell versus Keith Gross. 22 CR 0098. Are you Keith Gross?
Yes, sir.
You born in 1979?
Yes, sir.
It's 4 digits, social security number 6977.
Yes, sir.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir. But my credit for being in jail. It's like it says I got they served indictment on me on 7/6/23, and it just goes through the first this year, but I've not been out of jail. It's only 182 days of credit.
Counselor, do you know anything about that?
And Judge, what I would say is that in my experience, whenever there's a discrepancy with credit, that there is a administrative appeal process through the Department of Corrections that would happen after sentencing, in which they would attempt to correct a sentence and give their reasoning behind it, and then upon exhausting the administrative remedies, that the court would then have jurisdiction to correct his sentence if it felt like DOC had done it incorrectly. That's my experience.
I just wanted you to explain that to your attorney, to your client, okay?
Yes, sir.
Okay. Is there any other reason why this gentleman should not be sentenced?
No, sir.
It's a jury, I believe this was a jury trial, and they sentenced him to 9 years, and I make the findings that I believe it's appropriate to sentence him to 9 years. And then any kind of adjustments in his credit time can be handled administratively. Thank you very much.
Yes, sir.
I'm gonna waive the court costs considering the length of this sentence.
Your Honor, he has 3 other cases. I don't know if he wants to resolve those or not, if he wants to get his negotiation back again or not.
What are the cases? Is he, Counselor, what do you give your name for the record? You're not on the docket.
Forgive me, Judge. I'm Andrew Rhodes with the Department of Public Advocacy. I'm in the Elizabethtown office.
Yeah, are you gonna represent him in the other cases he has pending here?
Yes, sir, I am. And I've had some discussions with the
We have a negotiation day here on August the 2nd that starts at 9 a.m. that counsel and defendants appear at to negotiate. If you will appear on August the 2nd, and if you want your client here personally, if you'll submit a transfer order, we'll have him transported here. Transport order, rather, have him transported here, and then the next court date will be on August 15th, where he can resolve his other issues, okay?
Yes, sir. All of that sounds agreeable to us. I do have a previously scheduled mediation for another client in Butler County, I believe, but it's on August 2nd. Are you willing to give us the next mediation date and pretrial date?
September 6th, and we can do September.
September the 6th and September the 12th.
Yes, sir. And I will file that transport order for Mr. Gross to be there. And Mr. Gross, I'll be talking to you the next day or two about our next steps, okay?
Thank y'all.
Yes, sir. Thank you.
May be excused. Gary Hall. Comma versus Gary Hall. For sentencing.
Yeah, all of it.
Commonwealth versus Gary Hall, 23 CR 0040. Are you Gary Hall?
Yes, Your Honor.
Last four, you were born in 1978.
Yes, Your Honor.
It's 4-digit social security number, 6975. Is that correct?
Yes, Your Honor.
Here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Yeah, that's the one that's right above Mr. Bell's head there. There you go. Thank you, Mr. Bell. Okay, is it substantially correct, Mr. Bell? Is there any reason this gentleman should not be sentenced?
We only have one issue, Your Honor.
Okay, go ahead and bring it up.
The only issue we have, Judge, we had a split sentence in this case. He was credited 118 days. We believe that he's well beyond that with his ankle monitor time and everything else. There was also a contempt situation, but as soon as he gets done with his 180 days, he's going straight into a long-term treatment. So it's up to the court, I would assume, how much time that they want to credit, and I don't know.
Remind me of the contempt situation.
He was appeared for a jury trial and was intoxicated.
Yeah.
But he did appear, Judge, which is a one step in the right direction, and he has been in custody for some time, and he's going for long-term treatment. I
Well,
think he was on ankle monitor 6.
You know, the problem that I have with someone coming here doped up or under the influence is you have all these jurors that come here and inconveniences them, cuts in their day and everything. I can't think of anything, even cursing the court or that sort of thing is probably no more disrespectful than that. How much time did I give him? Did I give him a specific amount of time? How long has he been in?
100 days.
Okay, well, I'll cut his contempt time down to 15 days.
That's fair.
I give him a pretty good break on the thing, okay?
And will he get all of his ankle monitor time, Judge? That will put him.
Well, he's entitled to that as far as the credit for time served if he's violated. Now, he's got how many days on jail?
Gary, how many days you got in jail? 100 days in jail, and then he was on ankle monitor, what, 6 months?
6 or 7, yeah.
Go over the assault with me.
This is a case where he allegedly shot his girlfriend. The problem we got in this case is the two people that witnessed this, other than Mr. Hall, is her brother's deceased. And then after she gave a rape statement to Ty Hammer, she went to Mr. Bell's office and recanted. So that's the factual situation. I'm sure, I know at least one time she wasn't telling the truth.
Me too, Judge.
Went over to the truth seat. I just, on these shooting things, I can't do anything on that, I think. We just let it have an administrative calculation, what he's entitled to, and I'll cut it to 15 days I said on the contempt, okay?
Well, he gets credit for everything but the 15 days.
I think he's entitled to it.
Yes, sir.
They can do an administrative look at it. I'm not going to prejudge them. Y'all take a look at it. If you don't agree with what they've said, you can bring it back to me, right?
Yes, sir.
Okay, thank you very much.
Thank you, Judge.
Your Honor.
Yep. Nicholas Holland. Conwell versus Nicholas Holland. Are you Nicholas Holland?
Sir.
Okay, this is 23 CR 0041, pretrial diversion revocation, and a pretrial conference on 24 CR 0041. That's rather odd, Mr. Stockton, that you go a year apart and it gets the same numbers.
I noticed that.
Yeah. What do we have here in this case?
This is the case, he's co-defendant, Mr. Southworth, we did a trial already.
Okay, and what was that date?
August 14th.
August 14th.
Set for trial on August 14th. This is the gun case, correct? Your attorney is here and your co-defendant has already been here and they set the trial date. Your attorney will be over to see about this, okay?
Sir.
Thank you.
Krie Marley. Krie Marley. Commonwealth versus Krie Marley, 24 CR 0043. Ms. Marley is here for arraignment. Ms. Marley, have you filled out a form? Were you represented in district court by the public defender's office?
No, sir, I did something on the phone when they first arrested me on the board.
I'll continue the appointment. You have a right to remain silent. The grand jury of Monroe County's returned an indictment charging you with giving a police officer a false identifying information, possession of a controlled substance in the first degree. And possession of drug paraphernalia. You understand those charges?
Yes, sir.
Yeah, I'm going to sign a reciprocal discovery order here, which requires a Commonwealth to give your attorney all the information that you have. They have to help you prepare your case, and you'll come here on the 2nd of August at 9 a.m. to the Justice Center. You'll be transported. Your attorney will have you transport order done, and your next court day will be on August 15th, August the 2nd, August the 15th.
Now, do I have to stay incarcerated until then?
What's your bond situation?
I don't know, sir.
Don't have that information.
What is your bond situation?
Yes, Your Honor, it's $15,000 clerk approved surety.
That's a very low bond. All somebody has to do is come in and qualify with the clerk that they're worth $15,000, and that's not hard to do. You don't have anybody at all to come in and say. Okay. Do you have, where do you live, ma'am?
I'm at Brass. I'm not allowed to say my address.
Okay, she's in protective situation. Okay, I'm glad you answered that way.
We had to put it in scratch as well.
Yeah. Well, your attorney will come and talk to you about where you might live and where and if the Commonwealth agrees on some sort of restrictions, ankle monitor or something, we'll take a look at it. Okay. Okay. Thank you. Jonathan Scott. Commonwealth versus Jonathan Scott, 24 CR 0064. Are you Jonathan Scott?
Yes, sir.
You born in 1974?
Yes, sir.
Here for the purpose of arraignment. You have a right to remain silent. Did the public advocate's office represent you in district court?
I just come straight to that, sir.
Right here. Did he fill out an affidavit?
Check, actually, no. Looks like that he did. Second shift filled one out, so I will see if it's not in the file, I will get that. And put it in the file.
Okay, I'm going to appoint the public advocate's office for the purpose of arraignment in your case here. And I'll look at your affidavit to see if you're eligible to have a public defender. If I will, I'll appoint it. If not, you'll be informed, get a copy of the order. The grand jury of Monroe County has indicted you, Mr. Scott, for possession of controlled substance in first degree. You understand what the charge is? I'm not asking you whether you did or not. I'm just asking if you understand what the charge is.
Yes, sir.
Okay. I'm signing a reciprocal discovery order. It requires the Commonwealth to give you information to prepare your case. Your Your next date will be August the 2nd at 9 a.m. to be here at the Justice Center in Tompkinsville for the purpose of negotiation. And then the next court date is August the 15th. Both of them are conditions of your bond. What's Mr. Shirley's bond?
Yes, Your Honor, it's the same as the
Mr.
last
Scott,
one,
really?
the 15,000 clerk approved surety.
Yeah, that's a pretty low bond, Mr. Scott. Do you not have anybody come in and to the clerk's office and get approved on $15,000 surety?
Not that I can think of right off, sir, but can I speak for a second? I live with my aunt and my uncle, and I report to Mr. Collins every month. And I'm there religiously. I have no problem. Don't think.
You're on parole is what you're telling me, right?
Yes, sir.
How's he doing on parole? Okay, before this?
As far as this case, he's been
Well, I think I might ROR this gentleman and say that he has to stay at home under a curfew there where he's staying subject to checking in with probation and parole and pretrial, okay? You understand that, sir?
So ROR just under curfew and what the probation parole officer says, right?
That's correct.
Thank you, Your Honor.
In Monroe County language, I don't want you out gomming around, okay?
I won't, sir.
Okay, thank you.
Thank you.
Evelyn Shirley.
Your Honor, this is my ex parte motion.
Okay. Commonwealth versus Evelyn Shirley, 24 CR 00011. What do you have here?
Your Honor,
You gonna come up later?
yeah, I think that's best.
Do what?
We just like 2 or 3 cases when we finish, so we can.
Okay.
Yeah, if that's okay. Your
Ms. Shirley, we're gonna pass your case over. You have a right to a private hearing. Jeffrey Slay. Jeffrey Slay. Commonwealth versus Jeffrey Slay. Is Jeffrey Slay there?
Just a second, Your Honor. We didn't have him on our list. He
Okay.
is here.
Okay,
Let me
yeah, you send him on up and I'll go on down. David Teach Out.
I need Jeffrey Slay brought to the board.
David Teach Out.
Yes, sir.
This is 21 CR 0059. Mr. Teach Out, were you born in 1983?
Yes, sir.
Last 4 digits, social security number 0623.
Yes, sir.
On the docket for a pretrial diversion or revocation, what does the Commonwealth had to say?
Your Honor, he has a
3-year sentence on possession of a controlled substance, first degree. The last time we filed a motion to revoke in lieu of revocation, he was placed in the Monroe County Specialty Program and he absconded October the 30th of 23. So we're asking this diversion be revoked.
Your Honor, we actually did not receive notice of this revocation. I had noticed it on the docket last week and had emailed Mr. Stockton for a copy of the violation report. We did not receive it, and so we would ask if we could have the hearing next month. We've not been able to talk to him or review the allegations.
Okay, September 12th. Is he on the state dime?
No, he's on the Monroe County.
September 12th, Your Honor, or August the 15th?
Well, I don't know. I thought you said a couple of months. Come back over here. Come back over here. What about, what kind of notice did you give them, Mr. Stockton?
It was emailed, when you were on the distribution, but it was a late filing. This motion wasn't filed until Tuesday.
The Jeffrey Slay one we received on Tuesday. I didn't get one on David Teach Out on Tuesday.
Where are we gonna be next week? You want to take a look at it and you can appear by Zoom if you want to.
I can look at it, Your Honor. I may actually be out of the state next week, but I can look at my calendar real quick.
Are you gonna be where they don't have Wi-Fi?
Your Honor, I will be in the middle of getting my wedding dress fitted, so
But I can save you from that if you want me to. If you want an excuse to get out of that.
You said next Thursday, Donna?
Yeah. Take a look at it.
Okay, Your Honor, I think I could do next Thursday. Could we do it
Next
over
Thursday.
Zoom?
Yeah, we'll give you a Zoom link. You gotta hold on.
I won't have it set up until next week.
That's fine.
Okay.
Thank you.
Your attorney will be talking to you.
I'm gonna have to have a hearing, I mean, subpoena Mr. Grace.
And I don't think, from what I can see, this motion wasn't renoticed. December 23. And now, and I guess since he's been picked up, the motion they did bring up.
It didn't get it notes, okay, before he knows.
Okay. Thank you.
So we gave
Sorry.
you.
Oh, it was James.
Oh, it was James. Well, they switched up.
It's all sorts of cracks. This is falling through. Commonwealth versus Eric White. Are you Eric White?
Sir.
This is 24CR0019. Mr. White, were you born in 1985?
Yes, sir.
That's 4 digits, social security number 8918. You're here with the purpose of arraignment. You have a right to remain silent. You don't have an attorney listed. The public advocacy, were you involved in this? Has he filled out an affidavit pre-trial?
Yes, Your Honor, it's like, Reagan on second shift looks like she could complete one.
Does it appear he's qualified?
I do not have that here in front of me, Judge.
I will appoint you for the purpose of arraignment, and I'll review your situation to see if you're entitled to public advocate. You have a right to remain silent. The public advocate is standing in on your behalf here, Mr. White. The grand jury of Monroe County is returning an indictment charging you with fleeing or evading police in the first degree on foot, wanton endangerment in the first degree, and resisting arrest. You understand what those charges are. I'm not asking if you did or not, but you understand what the charges are. Is that correct? You understand what the charges are, Mr. White?
Yes, sir.
I'm signing a reciprocal order where the Commonwealth will give your attorney the information that they have to help you prepare for your defense. We'll set a negotiation day on August the 2nd here in Tompkinsville, and on August the 15th will be the next court appearance. What is Mr. White's bond?
Yes, Your Honor, it is the $25,000 clerk approved surety.
He charged one night between and evading and it's the guy saying.
Okay, well, you can have your attorney negotiate with the Commonwealth as far as your bond, okay? Thank you. Okay, now,
Judge, this.
okay. Dalton Birdwell. Dalton Birdwell. Commonwealth versus Dalton Birdwell. 22CR0051 and 24CR0058. A motion to revoke shock probation on the first case and a pretrial conference on the second.
Your Honor, the Commonwealth and I have submitted an agreed order that I believe that the court had signed to move this to the August negotiation date and pretrial. For grounds, Mr. Birdwell is
You
charged
don't
with.
need any grounds if y'all got an agreed order.
Yes,
August the 2nd and August the 15th.
thank you, Your Honor.
Yes. Your attorney will be over there. Now, we still have, I guess, what did we do on Jeffrey Slay?
They're supposed to bring up here now.
Are you Jeffrey Slay? Me, Jeffrey Slay. Commonwealth versus Jeffrey Slay, 21CR0071 and 21CR0072. Are you Jeffrey Slay?
Yes, sir.
You born in 1978?
Yes, sir.
That's 4 digits, social security number 8029. Is that correct? 8029 or last 4 digits of your social security number? Okay, you're here on a pretrial diversion revocation. What does the Commonwealth have to say? You want to come around, Mr. Stockton?
Yes, Your Honor. This is a motion to revoke pretrial diversion. He has two
two possession cases that he pled guilty to, and he got 2.5 years each for a total of 5. The basis for the revocation is a new felony arrest by the Cave City Police Department when he was charged with DUI second, possession of a controlled substance first degree. If we need to have a hearing, I'll have to subpoena the officer to be here.
Your Honor, I had spoken
If
with
you get
Mr.
behind the
Stockton.
microphone, speak up.
Yes, Your Honor. I had spoken to Mr. Stockton about this earlier this week. The motion for this case had been filed on Tuesday, so we had not been able to speak to Mr. Slay. I think this is probably one that we can work out without a hearing if we can just put it on in August.
Okay, look, the negotiation day is on August the 2nd at 9 a.m. And the next court day is on August 15th. Now, are you representing him over in the Cave City thing? And is that going to be in Barron County or is it on up in Hart County?
It's Barron County, Your Honor. As of right now, I believe that our office is representing him. CourtNet does have Mr. Garrett's name listed, but we are trying to figure that out.
Okay. Okay, your attorney will be able to talk to you, try to coordinate things that's going on in your DUI charge, and this here, she'll be able to talk to you, okay? Thank you very much. Okay, now we do have, what else do we have over? Yeah. We have, okay, we got one other person for an ex parte, Evelyn Shirley. So just keep Evelyn around there. We'll have to clear everybody out of the room when we talk to Evelyn, okay?
Your Honor, we just had one more, Devin Howard for show calls, and then we're all done.
What is it? Okay, who is it?
Devin Howard, he's on the show calls, and then we can get them all.
He's still in jail, so I put it off till next month. The show calls off until August the 15th, okay?
Okay, we'll get them out of here for you, and
Okay, thank you. We'll get right back to her. Okay, now we're back here with
Hershel Hammer, yeah.
I was trying to find Mr. Hammer. There he is. Number 5 on the docket. Conwell versus Hershel Hammer, 23 CR 0083. You are Hershel Hammer.
Yes, sir.
You were born in 2005.
Yes, sir.
Last 4 digits, social security, digits of your social security number 5631. Is this a felony or pretrial diversion?
It's a probation felony, Your Honor.
Felony. Motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Are you the same person I just announced in indictment number 23 CR 0083?
Yes, sir.
Is your judgment impaired today? Is your judgment impaired today? You know what's going on, don't you?
Yes, sir.
Okay. Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution.
Yes, sir.
I need to go over those rights. At the end of them, do you understand them? I'll ask them. If you don't understand them, I'll give you time to step away and talk to your attorney. You have a right not to testify against yourself. No one may say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called testify against you. Right to produce evidence. Right to call witnesses in your favor. Have process issued to compel their attendance. You have a right to appeal this matter to a higher court. If you lose, the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charge. You understand that by entering a guilty plea today, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event that I do not accept the recommendation that you've agreed to, I will allow and decide to impose a harsher sentence. I will allow you to withdraw your plea. Enter a plea of not guilty and proceed to trial. You understand that?
Yes, sir.
Okay, Mr. Stockton, you come around?
Yes, Your Honor. Okay, and Your Honor, this is on 2 cases, 23 CR 83 and 24 CR 25. That's correct.
I only have one on the docket here. The only thing I have on the docket is 23 CR 0083.
Yeah,
What is it?
all these cases should have been on the docket, I think.
Well, what is the other case?
Which one's
24 CR
25 is the one not on the docket.
What is it?
It's a theft by unlawful taking over $10,000, wanting endangerment, fleeing and evading.
What is 230083?
It's criminal mischief first, theft by unlawful taking, receiving stolen property.
Well, I'm gonna get a chance to see it again when I have a pre-sentence investigation.
It'll be a sentence.
Okay. Give the offer.
Upon a plea of guilty of theft by unlawful taking 23 CR 83, the defendant shall receive a sentence of 3 years. Upon a plea of guilty in 24 CR 25 to wanton endangerment, 6 counts, he'll receive a sentence of 2 years on each charge run consecutively for a total of 12 years. Then in 24 CR 25, he'll plead guilty to theft by unlawful taking over $10,000. That's a 10-year sentence. In the unlawful imprisonment charge in that same case number, he'll receive 2.5 years. Fleeing and evading police, 2.5 years. Criminal mischief, 5 years. They'll all run concurrently for a total of 12 years. The 15 years and the 5 year, 23 CR 25 and 23 CR 83 and 24 CR 25 will run concurrently, consecutively for a total of 15 years, probated for 5 years. It's to be supervised. The defendant agrees to cooperate and testify truthfully in an unindicted criminal case. He shall be released from custody on final sentencing. He'll pay $7,000 in restitution to Ryan Hunter at a rate to be determined before sentencing per month, and we'll enter a restitution order on that. He'll pay court costs at discretion of the court, obtain and maintain gainful employment.
Have you taken a statement on that other case?
Yes, we have.
Okay. Can you step around here? Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the crimes charged in the indictment?
Yes, sir.
Okay, you plead guilty of your own free will, knowing your constitutional rights is still your desire. Give up those rights, enter a plea of guilty, and allow the court to fix your punishment as permitted by law. You understand that after entering this guilty plea, any future convictions of felonies could enhance the range of penalty under persistent felony offender law. Is that correct? Is that your signature on the document?
Yes, sir.
You have the document in front of you?
We do.
I'll accept the agreement order, pre-sentence investigation report to be done by probation and parole, and schedule sentencing on August the 15th.
Thank you, Your Honor.
Thank you. And you want to come up here for your hearing? Okay, you have, what's the nature of this? Evelyn. Ma'am, your attorney made a motion, a private motion on your behalf, and he was successful. He'll be over to tell you about it, okay? Okay, is there anything else in Barron County?
Nope, that's all, Your Honor.
Thank you very much. You may be excused.
Thank you, Your Honor.
We got the show cause docket. Let's go off the record for a second. Ready to go? Savannah Acosta. Okay, there's been a payment August 15th, the next day. Victor Baez. $465. Has there been any response from Victor Baez? Hold him contempt. Can purge himself by paying $465. Teresa Botts. How much you pay? Okay, put her back on August 15th. She had two of them, right? She had a total of $1,908. Is that correct?
Hey, Judge, if you just, I don't think you knew that, the majority of these are paid, and then we need to call it. I don't know how they're on the dock, that I can pull out the material. Let's see, if I have 50. Unless you want to follow.
Just enjoy it.
Don't.
Commonwealth versus Boyd. Okay, August 15th. Mr. Hunley, you want to stay around for a second? Yeah. Commonwealth versus Stephen Bray. Okay. Mark Brown. Gary Emberton. Dylan Ford. Billy Graves. Okay. Tyler Graves. Carolyn Hall. Carolyn Hall. No response. $200. It's your bench warrant. You purge yourself paying $290. Christopher Hill. $1,785. No response. Take him into custody. Purge himself temporarily for a payment of $785. Devin Howard, he was in jail. We passed him over to next month on both his. That'll be to August 15th on both of his, all three of his. Maxie Huff. Now what, he owes $774. What was this for?
For court cost and for the mirror that was wore off the top part, sir. I was gonna pay some on it this morning, but I had a bench warrant from a couple weeks ago that I did not know about, so I had to pay that this morning. Will you give me till Friday to start paying on it?
How much can you pay by Friday?
I can pay at least 75.
How much?
At least 75, no less.
That'd be good. You pay $75 by close of business on Friday and then come back here on August 15th to make another.
How much, sir?
I tell you what you'll do. If you pay $75 Friday and $50 a month on it there on out, you won't have to come back again, okay?
All right,
If
God
you
bless you.
hadn't paid the extra $50, be back here August 15th.
All right, thanks, sir.
You're on, whenever you took your plea, you was on an ankle monitor, but snuck and get, take the ankle monitor off. You did get better at drug court this morning.
Take it off of it.
God bless you, sir. Thank you.
Hey, be good in drug court now. Judge Christie will work with you.
I'm looking forward to it, to be honest with you. I'm trying to become a preacher and everything else, so this area is just one step.
Well, Judge Christie will work with you, okay?
Thanks, sir.
Or on you, depending on what you do, so. Commonwealth versus Justin Hunt. You pay something, Justin Hunt? $4,933. How long has it been since you made a payment? You know?
Probably like 50.
Looks like you did what?
They're showing a payment, but it's not processed through our account yet. They pay online.
How much was it? So it's a recent payment of 50? Okay, we'll have him to pay $933 by August the 15th, or be here to show cause why he should not be in contempt. I want him here, okay? Brian Hunter. Conwell versus Brian. Are you Brian Hunter? You're $140, is that right?
Yeah, I believe that's right. I made a $25 payment last week, but I'm in the process of finding me another job because I'm in drug court and my
Can you make a $25 payment by this Friday?
this Friday, I don't know. I got job interviews and stuff today.
Well, let me give you next Friday then.
Okay,
A
that'll
week
work.
from Friday.
Okay,
Make
okay.
another $25 payment a week from Friday, and then pay it after that, just pay it $25 a month to catch up.
Okay, 25 a month.
Yeah.
All right,
Okay.
thank you.
Courtney Mabry.
8:30, neighborhood hall.
Okay. Charles Muse.
8:15, neighborhood.
Okay. Charles Muse again. Titan Neal. It's your bench warrant purged by paying $240. Jesus Padilla. That's always,
Well,
This is the elder, I believe.
if it's the elder, then he been.
His restitution's only $1,000 and the younger one had almost $20,000 in restitution. So I believe this is.
well, let's issue a bench warrant here.
Like you can be in court.
We give him another chance at America here.
Unless you
Austin,
want him to pay.
bench warrant, he can pay $500 and purge himself for a period if he pays $500. Austin Pruitt.
8:30, neighborhood.
Okay. Maria Rivera, excuse me. She just owes $18,399.95. Mr.
It's an active one. Issue of license.
Is there a warrant out for her, you're saying?
I'm checking. I feel like we ordered one last.
Well, restitution is a pretty good deal if you don't have to pay it.
Oh, that was in February. She paid $200.
Okay, issue a bench warrant. She can purge herself by paying $1,000. That's how far behind she is, or $200 a month. Alicia Russell. Should make a payment look like? If not, issue a bench warrant. Alicia Samantha Russell. She can purge herself by paying $385. Patrick Harley Scott.
50, neighborhood 15.
That'd be fine. Spencer Shockley.
8:75, August 15th.
Okay. Travis Smith.
300, August 15th.
Okay. Christopher Stillwell. Should bench warrant, purge himself paying $65. Andrea Stinson.
850, August 15th.
That'd be fine. Hunter Strode. Hunter Strode. 235, issue a bench warrant. Purge paying $235. Eric Taylor,
Activity August 16th.
that's fine. Jamie Watson. Are you Jamie Watson? Okay, it appears that you owe $1,410. What do you have, what do you have there?
Paper from rehab, I've been in rehab since I got out of jail. As of right now, I'm not
You
allowed
need
to
to
work.
speak up a little bit.
As of right now, I'm not allowed to work. I'm still in the, I'm not sure what it's called. He's one of the workers. So,
What is this $1,400 for?
Cost funds and fees.
So there's no restitution involved? When are you gonna be able to go back to work?
60 days. I just ran out pay this morning.
Okay, I'll give you, I don't know when that is. When did you come in?
I came in on, went in on, June 27th of this year.
He's in treatment with us.
Pay $50 by October 17th. That gives you 30 days after you get out and $50 a month after that till you get it finished, okay?
Judge, it's a $500 fine on failure to maintain insurance and a $300 fine on DUI plus costs.
Yeah, so you gotta pay them.
Yeah.
So you start paying at $50 a month and you have your first payment done by October 17th. It'll be back here, okay?
Thanks, sir.
Okay. Ansel Williams. Ansel Williams. Ansel, you owe $215. Are you still in rehab?
Yes, sir.
Where are you in rehab at?
I'm at, Sparks,
Yeah, when you gonna be able to start to work?
about
3 months.
3 months.
Okay, you just owe $215. So if you pay $50 by October the 15th, October 17th, we'll be back here and then pay $50 a month after that, okay?
Yes, sir.
Okay, be on your way rejoicing. Good luck to you. Second, is that conclude the show cause docket? Well, I guess we're in recess until 1 o'clock then, okay? Enjoy that. Mr. Hunley,
Yes.
come back and talk to Rumpole for a second.
I think you're right.
Did Anne Marie ever find Rumpole? You ought to make it required.
No,
You ought to make it required continuing legal education. I know.
I think it should too.
I think Megan enjoys Rumpole.
Hello, Russell. If I could cross-examine like he can.
Well, if you don't have a judge, it's fine, it's hard. That one where he goes somewhere, he gets some military court.
All rise. Monroe Circuit Court's now in session. Judge David Williams presiding.
Thank you. Everyone have a seat, please. Call the child support docket. Oh. Russell versus Curtis.
Continue to August 15th, please.
Fox versus Fox.
Continue to August 15th, please.
That's about 13 years worth of that. Huh?
Yes, it is.
How much, what do we got left on that?
I think the last child is not emancipated yet.
Oh, well, okay.
They came in the other day.
Gallup versus Gallup.
Continue to August 15th, please.
Turner versus Guffey.
In the Guffey case, we'd continue to August the 15th, please.
Heston versus Heston.
Continue to August the 15th, please. I know that one is 17 years old. The child.
Hudson versus Hudson.
Continue to August 15th, please.
Jimenez versus Jimenez.
August the 15th, please.
How'd I do on the pronunciation this time? Is it good?
I'm still waiting for you to get the first name.
Well, I haven't gotten that. If we have two Jimenez versus Jimenez, I'll try to work on the first
Okay.
initial.
Okay.
Joyner versus Joyner.
Continue to August the 15th, please.
Keith versus Keith.
Continue to August the 15th, please.
Pennington versus Pennington.
Judge, this last month you adjudicated the arrears and we left it blank and said to make monthly payments towards the arrears in the amount of blank. And we had asked the court to come up with a figure. And David Cross said he was going to Zoom with us today.
I see the Zoom link he requested this morning.
On behalf of Mr. Pennington to where we could, we just want a repayment amount so that he can start working on this arrearage.
How much is the arrears?
31,000. Oh,
He made the $3,000
yeah.
payment.
27,844. It was 30,000 and he's made a $3,000
How much do you
payment.
want to put in there?
500 a month.
Okay, just enter an order.
Do you want us to resubmit an order with that amount filled in?
Yes, please.
Yeah. Okay.
And electronically file. Pruitt versus Pruitt.
Continue to August
No,
15th.
it's not intervene.
Oh, this is our motion to intervene just so that we can provide services.
No problem. Submit order. Brown versus Scott.
Continue to August 15th.
Thurman versus Thurman.
Judge, we are pleased to announce that this matter is continued generally as the child has emancipated and all child support has been paid. So it will be removed from the docket.
Would you like a photo? Group photo on one like that. We don't get one like that very often, do we?
No.
Okay, thank y'all very
Thank you.
much.
This is a new child support worker, Sarah Guffey, and today is her first day, so we thought we'd break her in right.
Let me see you like that. You gotta act like you can scare them to do this job.
Barbara Richardson back up here to train her.
Yeah, that's exactly right. She could put the look on her. Mid-South Capital Partners versus Aaron Heidman, also known as Aaron H.
Afternoon, Judge.
Hello.
I filed a motion, I don't know if anybody else is here or not, on behalf of the defendant Heidemann. And with that, some exhibits, Judge, that show that in a divorce and in a Tennessee action, his spouse was awarded this property, but apparently a deed was never done to consummate that order. And so we're asking for an order of the court to quiet his interest in that, or some form of a commissioner's deed to quiet his interest in that property.
Where is the opposing counsel? Did you serve anybody?
We did, Your Honor, and I thought there was an email from them. I also think, Judge, maybe I'm wrong, but you set this case over from last month till today.
Yeah, I think I did. Because I didn't want to I was worried. Remember asking if the piece of property was upside down, whether it would bring enough to pay for it. You think it is upside down?
I do believe it is, Judge.
Who is counsel on the other side? I don't see it. I guess Scott Basil.
Judd Patterson, Your Honor. I believe is correct.
Well, says for the defendant. I don't understand.
Judge, if you'll recall, last month I'd been retained to stand in for
Oh,
Mr. Patterson.
yeah, I do. Yeah.
And the order just asked for an in rem, Judge. It's just against the property, but they had named the title holders in the lawsuit, but it's just a judgment against the property. It's all what the judge asked for.
Your Honor, we don't dispute that. That is what it asked for.
Well, do you have any case law where if you got a piece of property in your name that you can take it out or extinguish it? That it bothers me that you can't, that somebody has a piece of, we're always, and we all know that there are always these things where people are ordered to take pieces of property out of their name in these divorce things and they don't do it, but if it is an in rem action, wonder if they would sign any kind of document that would say that they will not hold this gentleman that they have no intention of holding him personally liable for any deficiency judgment. That would be stronger than doing it this way. You know what I mean? Could you enter a negotiation with him and put in a statement that previously the property had been transferred, so and so and so, and all parties acknowledge that he has no personal liability on the judgment?
We will gladly do that, Your Honor. I will tell you, I've been unable to get in touch with this attorney. The number I have for him goes to a voicemail that I don't get returned.
Is that Judson?
I have his contact. My office has his contact.
Okay, well, let's just see if we can get that to give certainty to this gentleman that it won't ever come back and bite him again. And I know that's what you're trying to do for him.
Yes, sir.
Is to give him some certainty. And that's the reason I gave him some time to come back and get an attorney. So let's see if we can do it that way rather than trying to get in a situation where we do something that those other people might challenge sometime as to whether we could do it. I'd rather get an agreement with them to limit it just to the property. And I think you stated last time, Mr. Aaron, that you had no interest in receiving anything out of the property. You just didn't want to get stuck with a bill that wasn't yours. Isn't that right?
That's true.
Okay, well,
And you stated that they would come after me for what the property didn't bring.
I believe they would. I believe they
This
would.
gentleman stated too, that they would want to come after.
That's why he's asked us to handle it.
That's why I'm trying to help you with it. And everybody, is because I believe what you say, and now they've got the documents to show it. I believe what you said when you were up here last time, that the property wasn't yours and it was supposed to be transferred. But what we all agree to now might not be what some company that buys all these liens from another company. Let's say one company sells all their liens to somebody else. You need it in paper and you need it on the record. Okay, thank you very much.
If I may, I have gone through this after somebody promoted today, and I believe it's premature or sale anyways. I don't believe they served everyone that they should have. There was a Brenda Hatterman on the deed.
Yeah,
They-
her estate.
They served the unknown spouse of Mr. Hatterman rather than Miss Brenda Hatterman or the unknown heirs of Miss Brenda Hatterman. So I would like to see they served those parties before.
Who was the warning order attorney?
I'm sorry.
It was you.
Oh, great.
And Holland.
But they were not named parties.
And Holland only.
Correct.
Two one and one
Yeah.
attorneys listed.
So they were not named parties in this way.
They weren't named
Yeah.
parties in the suit, but she were named on the deed. So she should have been sued.
She's listed as a party as a unknown spouse.
Which is an actual party, not an unknown stuff.
Right.
It has her name listed.
No, it has her as the unknown spouse listed as a party.
I think the plaintiff's probably aware she passed away. And it's probably why she wasn't listed, but her heirs would be potential.
Who are her?
The issue you've raised with the separation agreement severing, her estate would have to be named.
That's what-
because You're saying he has no interest in it. So to get rid of any interest her estate may have, they would have to be the heirs.
That's what, yeah, I agree with that.
Or, well, not the estate itself, but the person to it passed to,
Yeah, the heirs.
unless a will put it in the estate. Okay, well, y'all got a little work to do on it, but we're making progress. Okay,
Thank you.
thank y'all very much. Short versus Cook.
Janie, you all can just stay there. You all can just sit in.
What do you have, Mr. Pointer?
Your Honor, this was a forcible detainer eviction action in district court. I can wait until the cooks approach. We had a hearing in district court where.
Who you represent?
I'm sorry, I represent Janie Short, the plaintiff.
Okay, and you are Ricky Cook?
Yes, Your Honor.
And who's this with you?
This is my wife, Sierra Cook.
Glad to meet you, man. Okay, what do you got here?
So we had this eviction proceeding,
Is this the file?
where Mr. Cook states that there is a contract where he paid $30,000 cash to Janie Short for a 10-year lease on this property. But then he testified under oath that he never delivered the $30,000 to her. And the judge in district court felt that because of the amount involved, it should be transferred to circuit court. So that's kind of where
It was
we're
an
at.
interest in real estate too, probably had to come up here.
Yes, sir. So I wasn't really sure how you wanted us to proceed. If you wanted to schedule just a hearing on the matter and put on testimony or.
Well, I've never really run across anything where somebody tried to do an eviction notice. You wouldn't do it by virtue of an eviction notice, obviously, because that's you probably file some sort of litigation as far as trespass or something like that, and they would claim adverse possession. How long have they been on the property? How long y'all been on the property?
Total of 3 years. This contract was done 6 months ago, 8 months ago now.
Do you have a copy of the contract?
Yes, Your Honor, I do.
Well, I don't want to look at it necessarily, but what you need to do, I think what you need to do is these eviction cases do not feather out the claims very much, do they? You know what I mean?
Right.
They just say they were wrongfully in possession of it. And what I think I'd ask you to do is file a complaint in the thing and set out your causes of action, and then give this gentleman an opportunity to answer it. And you need to lawyer up, is what you need to do. Okay?
I talked to Basil the other day.
Well, I know, but I don't,
Today.
yeah. Until, you really have to give him something to answer, you know what I mean? And then you can hire him, he can come in, and then the two lawyers can try to work through the things. Yeah, if you stay in the case now, I have to hold you to the same standards that I would a lawyer, and that it's not really fair, but that's the way it is. So you'll need to lawyer up. Now, what kind of piece of property is this?
It's a small house on a piece of land.
112 acres.
No, the 12 acres is not part of the contract.
Definition of premise is the house and attached properties.
Not in the contract, Your Honor. Contract was strictly for the house.
Well, I haven't seen the contract, so that would be part of his answer. You file a complaint that they're trespassing.
Yes, sir.
Any damages, and then you'd have to describe what they're trespassing on by description. Then your lawyer can file an answer and a counterclaim saying what you think you bought in the contract, and then y'all can take some evidence, and if we can't settle it, we'll let a jury decide it.
Yes, sir.
Okay? I'll give you, 15 days to file a complaint be
Yes,
enough? If they're gonna give you 15 days to file a complaint, and you're here and already before the court, you and your wife, are y'all gonna own this property together? Is that right?
It's just a lease, Your Honor, what started
Yeah,
out.
it's not a purchase.
It's not a purchase.
Well, I know, but y'all gonna, you have the ownership interest you have is a lease, that's it. Okay, so, but y'all were gonna have this lease together, you were lessees together. So, then you can file both of y'all have entered your appearance in this case, okay, so they don't have to serve you. When you get a copy of this complaint mailed to you and make sure he has a good, then you'll have 20 with a summons on it.
Yes, sir.
You have 20 days to answer it after he sends it to you. Okay? Okay, thank y'all very much.
Thank you, Your Honor.
Yeah. Donahue versus Donahue.
Hi, Your Honor. Spencer Pearson here for Josh Donahue, the petitioner. It's our motion.
Your Honor, I'm here on behalf of Melanie Donahue.
Okay, I file here.
We have filed a motion to modify their parenting time and custody agreement in two ways. Since the parties entered their initial one, both have moved. They were supposed to meet midpoint and exchange the children. Since November, responded.
Where are they supposed to meet now?
Louisville, Kentucky.
Who moved?
Both have moved at some point. I think this, and you may know better than me.
Where's your client live?
She lives here.
She's at one.
Moved, huh?
She's at one point when they first started the proceedings.
They both lived in Clay County, Tennessee, and then they moved here.
Yeah, he lives in Indiana now.
Well, they both improved themselves.
All we're asking is to adjust the.
But he's the one that moved to Indiana?
Yes. He moved. He lived in Indiana for some time.
You on the line here? Is somebody have?
Yes. He's on the line.
You want to put your camera on, sir?
Maybe.
There you are. There you are. Okay, and where do you want to, how often do they exchange the children?
A few times a year. I'm not sure exactly how many
So,
times.
if I may, we exchange. I get my children every month. As it stands currently, I have to pick them up for anything not a long vacation. So anything like Martin Luther King Day or 3-day vacations. I have to go all the way down there, pick them up, and bring them all the way back.
Where do you live? Where do you live, sir?
Tipton, Indiana.
Where?
Tipton, Indiana.
Vincennes.
Tipton.
Tipton, okay.
Mm-hmm. We just found a middle point that is in Henryville.
Hey, do you have any law that if someone moves somewhere else, that the other spouse is responsible for delivering the child halfway to where they move?
I do not think so, Your Honor, but
I'm always interested in some law.
This was brought in via our petition to register a foreign decree. This initially was a Tennessee case. he moved to Indiana during that point. She has moved here. They both moved enough where the new would be more conducive to be in Henryville, Indiana, which directly puts them 142 miles each from the new midpoint.
Clay County is about 15 miles from here. Okay, Mr. Carter. Was this a Tennessee case?
Yes, sir.
So
wait, sir, you got an attorney here, okay? This is not like small claims court, okay?
Mhm.
Okay. Where did the petition was filed in Clay County, Tennessee?
I was wrong. I think it's Macon County, Judge.
Well, what town is that?
Lafayette.
Lafayette.
It's like 45 minutes.
I know where Lafayette is. I can't keep up with the counties all the time, but I know where Lafayette is. That's where we pay our light bill. So initially, and then they both moved here to Monroe County, Kentucky, correct?
He has never lived in Kentucky.
Okay, where you moved from Macon County to here, okay, and he moved from Macon County,
to Indiana at the beginning of our divorce.
okay,
Which
and has
was
lived up there
2006.
continuously since
And I
then?
believe the divorce proceedings started in Indiana, correct? In
Wrong.
2016.
Tennessee.
I think my client would state that it started in Indiana, the divorce proceedings.
Says Tennessee.
Our position is everyone has moved around. He's just asking to adjust it to a midpoint for both of them, especially
Okay,
because for
how
the
about
last,
Glasgow being the midpoint?
I don't believe Glasgow would be the middle point for him.
Well, it's the thing about it, what if he moved to Montana? And he decided he wants to go to Indiana, and that's fine. But if you put the midpoint between Macon County, let's go back to Macon County for a second. If you put the midpoint between Macon County and wherever in Indiana he lives, where would that be?
Most likely Louisville, around that area.
Well, how far up in Indiana does he live? How far is it served north of Louisville do you live?
it's 130, roughly 145 miles.
North of Louisville?
Yes, sir. It's a 2.5-hour drive.
From Louisville it is.
Yes, sir.
Where do you want her to bring these children to?
Henryville, Indiana, which again, we've printed out this where it's 146 miles each for each of them. This became a bigger issue because he's been having to continuously go the full length anyways. So that's why this was brought up in the first place.
Your Honor, I don't mean to cut you off. I will point out that she has provided gas. There has been 3 occasions that she would admit he's had to drive here, and she has paid at least $100 on each occasion towards his gas. 200 twice and 100 once for his gas money for having to do that. But that's on 3 of the visits. But they're already
How old are the children?
to Louisville, 16 and 13. Is that correct?
Well, yeah, well, it's actually 15 and 13. She'll be 16 this year.
Well, I want you, both of you to kind of brief what someone's responsibility is to meet halfway or whatever. I don't know. I'm not a family court judge, and I've really never had a situation where someone moved that far and then asked to split the difference. It appears to me that one of the parties, probably for, I don't say for justifiable reasons, employment or whatever, decided that it was better for them to live there. But I don't see how they could move that far away and impose upon the other parent, you know, the cost of paying half the transportation because they moved away. Maybe they could take a lesser job and live closer to here. You know, that's, so I want y'all to brief me on the law or equity that's involved in ordering this lady to drive them way up in Indiana, you know? So how many days you need? 20 days to brief it, or you want
perfectly fine.
20 days and you need 20 to respond, and you can reply in 10, okay?
Okay, and-
Once you get me an order of that effect, okay?
Of course. And Your Honor, there was one more modification we requested.
Okay.
Currently, their settlement agreement had them not communicating by phone, only letter, or it has become exceptionally inconvenient for my client.
Who not come, who,
She,
the
I
two
believe,
parties not come?
I believe respondent doesn't have a cell phone, or she claims she does not have a cell phone in her
Well,
objection.
you say they weren't communicating. It's not the children. It's the mother and father aren't communicating.
Mother, father, not.
Well, there's an app that people can use, and it appears to me that there's a level of animosity here that both of them ought to have. What is that app, Megan?
We use App Close and up closer to Louisville, and there's also one called My Family Wizard.
Would you remember what that is? We used it.
Oh, she said she was nice.
Well, she can get one.
Your Honor, we have pictures. She has social media.
Well, I don't want to get into pictures and stuff. I'm trying to read resolutions. I mean, I don't think, you need to get a cell phone. Okay. I mean, well, here's the thing about, y'all need to document communications with each other. He said, she said, they called you, he didn't call me, he said this, he said that. It would appear to me that any communications y'all have about the children should be documented. And it should be in writing, like texting back and forth. Shouldn't be by mail or anything. It takes too long. There needs to be some immediacy in it. And what kind of phone do you have now?
House phone.
You don't have any kind of mobile phone at all? Well, that first person I've ever known had one of those, yeah. Well, I'd cancel my landline and then invest in yesterday was Prime Day on TV, on Amazon. You could have gotten one yesterday on Prime Day. So
Yeah, I think we'll make it work. Joe.
make it work. And that way y'all have documentation, have communication both ways so that you'll know, like if you have to notify him when they're at the doctor, if he has them, he has to notify you. Okay? Okay, well, y'all get some kind of agreement on this, you can always contact me.
Thank you, Your Honor.
Okay, thank you very much. Mid-South Capital Partners versus Phoebe Hawkins.
Good morning, Your Honor, or good afternoon, excuse me. Hunter Jones for the plaintiff. This is my motion for judgment in order of sale.
Is this a tax lien?
It is, Judge.
Did they file an answer?
There has, Ms. Copas has filed a response. I believe her husband filed a response. We actually dismissed them. This was interim only. They said they had no interest. We agreed to dismiss them on the condition that they would be listed as a grantor in any master commissioner deed.
Madam Master Commissioner, gives us a way to do that. Have you looked at this?
I have, Your Honor.
Is it good to go?
It is, and I'll sign the order today. You sign.
Okay. And have you looked at the cost did y'all see that they got a document in doing what you want to do here?
Sounds good to me.
Okay. Okay. You want to look at this? Okay, we'll enter the order, okay?
Thank you, Your Honor.
I'll review it as far as what you're charging these folks. Ford Motor Company versus Jonathan Rivera. Is that this case? They're wanting to transfer this case out of my circuit. Is that right?
I'm not concerned on.
Surely they don't think I would sign a case transferring one of these. Well, I'll go ahead just this one time. You want to look at this? Look through it briefly, see if there's anything I haven't seen on it. Yeah. Rouse versus Rouse. Motion to compel, Holly Coleman. Mr. Carter, you're listed in this case here. Rouse versus Rouse. The file.
Either Emery or Holland. Yeah, I'll get close to that comes from.
Okay. Let's see what we got here. Well, there's an unsigned order here. Rescheduling this for today at 2:30.
Okay, well, that was supposed to be the 2:30, then, Henry told me that her, something's going on, they can be here, they're gonna reschedule.
Passover.
Yeah.
Okay. Passover. Turner versus Turner.
Judge. That is my motion. For the master commissioner. To sign a deed. There was a divorce action and the separation agreement and the decree ordered that Edward Turner's wife, that he would get all of the real estate. But there's never been a deed to effectuate the terms of that, and we can't find the former spouse. Edward Turner is deceased, so we intervened as on behalf of the estate to clear up the title.
What do you have to say?
I'll sign it.
I order you to, right? Thank you for your input.
I see no issue with it.
The divorce, the separation, or no, the decree ordered that he got all of the property he got from his grandfather.
And she didn't sign it and
There's
left.
never been a
Was
separation.
she in front of the court?
She is by, I believe, a warning order attorney.
Okay, well, submit me an order.
We have,
Okay.
yeah, everything's in it. And then the two heirs that with Turner are trying to divide up the property amongst themselves. We couldn't do it without clearing up this cloud on the other state.
Mid-South Capital Partners versus unknown heirs of somebody.
Yes, Your Honor, is that 20 CI 114?
That's correct.
Hunter Jones for the plaintiff. That's my motion for judgment in order of sale. Judge, this came before the court previously back in 22. The court took it under advisement, but we never got an order out on that. So I don't know if there were corrections that need to be made or if this got lost in the shuffle, but
Get that file. Okay, we'll take a look. What was the original tax bill in this thing? $600 or something? What?
there's two, Your Honor, one from 2009. I don't know what it would have been if they paid it on time, but by the time my clients purchased it from the county, that one was $684. The 2010 bill was a lot lower. There must have been a reassessment. It was $173.
Did the landowners ever come forward with any answer or anything?
No, Your Honor, the record owner is deceased. Added one potential heir that I believe we found through an obituary. But for the rest, since there was no will or affidavit of descent, I just named the unknown heirs.
Mr. Stevens, I see where you filed an answer on behalf of the county.
We just want the tax bills paid so that we can provide the goods and services the county's citizens.
We already been paid $800 for those delinquents. I
I'd
don't-
say there's other tax bills that are delinquent now. That we will add in mind.
Yeah, I believe every other year is still delinquent.
Okay, I'll sign an order. We'll take a look at the amounts you claimed.
Thank you, Your Honor.
This is Mid-South versus Webb.
Or that's also plaintiff's motion for judgment and order of sale.
Yeah, Ms. Webb is here, and it's my understanding she has no objection. Yeah.
Okay, we'll sign it and take a look at the claims that were made. Okay, thank you.
Your Honor. Have a nice day.
Is there anything else to come before the court? There's a confidential matter scheduled at 2, I believe.
Your Honor, the Pennington case, I got on about 8 minutes after 1, and was that called at 1 child support case?
Yes.
Well, I was appearing for Mr. Pennington, who's actually at the doctor today, and Mr. Stevens and I had talked. I just need to know what the court set for. If the court established a monthly repayment, I need to know what that is.
$500.
Okay. All right. Well, I will respect that at this time, and if we need to do anything else, we'll file it. But I apologize for being late. I could say I got caught in traffic, but we can't say that anymore with Zoom, so it's fine.
Thank you.
Thank you, Your Honor. That's all I have.
I think the new thing is going to be my Wi-Fi wasn't working properly. My bandwidth was something, I don't know. Okay.
Mr. Cross and Mr. Garrett can get together. And
Yeah, y'all think of something. You and Garrett will think of something.
We will. We will.
Is there any other
That'll
matter?
be fine.
Well,
That'll be fine. Thank you.
Any other matter